Good morning, everyone, and welcome to this meeting of the BCP Licensing Sub-Committee. The first item on this morning's agenda is the election of chair. I'd seek nominations for the position of chair for the subcommittee. Members?
I would like to propose yourself.
Thank you, Councillor Chapman-Law.
And I would second that.
Thank you, Councillor Farquhar. Can I ask Democratic Services Officer just to run through the housekeeping, please?
Thank you, Chair. Please note that this meeting is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, although ultimate discretion in this matter lies with the Chair in case of disruption. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building. Finally, please ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on your laptops. Thank you.
Thank you. Item 2, apologies. Do we have any apologies for absence for this morning's meeting?
None received. Thank you.
Thank you. Item 3, members, declarations of interest. Members, do we have any declarations of interest in respect of the agenda items for this morning's meeting? Councillor Chapman-Law.
None here, Chair.
Thank you. And Councillor Farquhar.
None from me, Chair.
Thank you. Item 4, protocol for public speaking at hearings. A protocol for public speaking at meetings of the Licensing Subcommittee is included with the agenda sheet for noting. Item 5, this exclusion is no longer required as we will now consider an adjournment at item 6. Item 6, consideration of the continued suitability to hold a hackney carriage and private hire driver's licence. The subcommittee has received a request from the applicant to adjourn this hearing until February the 2026 due to personal reasons. The licensing officer supports this request. Are members happy to agree to adjourn?
Yes, Chair.
Thank you.
Agreed.
Thank you very much. Right, I will now adjourn the session until the next item, which will begin at 11:15, and that's for those members of the public who may be watching on the live streaming. Thank you.
Thank you, Chair.
Good morning and welcome back to this meeting of the BCP Licensing Sub-Committee. Before I move on to item 7 on this morning's agenda, I'll ask the Democratic Services Officer just to run through the housekeeping measures. Thank you. Good
morning. Thank you, Chair. Please note that this meeting is being recorded by the Council for live broadcast and will be published on the Council website for a minimum of 6 months. The meeting may also be recorded or streamed for live or subsequent broadcast by members of the public, or their ultimate discretion in this matter lies with the Chair in case of disruption. For those in the room, please note that if the fire alarm sounds, please exit the building by way of the nearest available signed fire exit route and make your way to the assembly point at the War Memorial in the gardens opposite the front of this building in Bourne Avenue. Finally, please ensure background noise is kept to a minimum and mobile phones and other devices are turned off or switched to silent for the duration of the meeting. For those in the room, this includes turning off microphones and turning the volume down completely on your laptops. Thank you.
Thank you, Michelle. I just want to check that the camera's focusing on the legal advisor rather than myself. Can I just check? Yeah, that's better. I'll use this other microphone. Okay. Item 7 on this morning's agenda, application for the Beach House Mudderford Beach Sandbank, Bournemouth BH6 4EW. I will now ask each participant to introduce themselves and state their role. I'm Councillor David Flagg and I'm the elected chairman for this morning's subcommittee meeting.
I'm Councillor Chapman-Law for Alderney and Bourne Valley, member of the subcommittee.
Councillor George Farfra for Boscombe East and Folkestone and a member of the subcommittee today.
Thank you, members. Moving on then to the BCP Council, please.
Tanya Jardine, Licensing Officer. I'm sorry, everybody. I'm Linda Cole, the legal advisor to the subcommittee today.
Good morning. I'm Michelle Cutler, clerk to the licensing subcommittee this morning. Thank you.
I'm Christiane Tan, Democratic Services, observing for training purposes.
Thank you. And for the applicant, please.
Good morning, councillors. My name's Gary Grant. I'm the barrister acting for Mudderford Sandbank Beach Huts Association, the applicant for review.
Thank you.
Good morning. My name is Darren Pidwell. I am the current chairman of the Sandbank Beach Hut Association.
Thank you.
And I'm Claire Bath. I'm the deputy chairman of the MSBHA.
Thank you. I would normally ask people who are speaking to introduce themselves, but I think at this point it might be easier for me to call your name and you could just acknowledge the fact that you're actually with us here this morning. So Ms. Susanna Bath, I think, is on Teams. I'll carry on through the list. Yeah. Mr. Peter Jones. Thank you. Dr. Nicholas Goddard. Thank you. Mr. Stephen Barrett. Thank you. Mr. Paul Owen. Thank you. Miss Sally Harris. Thank you. Mrs. Elizabeth Pritchard. Thank you. Mr. Tony Webb. Thank you. And finally, Councillor Judy Richardson, who is speaking on behalf of Richard Bath, I understand. Thank you, Councillor. For the premises, please.
Good morning. My name's Gerald Gurrier and I'm a barrister acting for the Beach House.
Thank you.
Perhaps they can go 1, 2, 3.
I'm Richard Slater. I'm operations manager with the Beach House.
Kim Slater. I'm the DPS at the Beach House. Jeremy Carpenter, Operations Director for the group.
Thank you very much. Before I run through the procedure, please may I check that all persons who have given notice of their intention to speak have been identified, and any person who wishes to withdraw a representation or wishes not to speak has been identified. If there are no comments, I will take this as correct. I will now explain the proposed procedure and order of speaking for the hearing as follows. The licensing officer presents the report. Questions of the licensing officer by all parties, members of the subcommittee to go first. The applicant will make their application. Questions of the applicant by all parties, members of the subcommittee to go first. Persons representing the premises will make their representations. Questions of the persons representing the premises will be asked by all parties, members of the subcommittee to go first. All parties will be given an opportunity to sum up at the end of the proceedings with the party who spoke last to go first. But I would like to think that as there's so many representations this morning, that you will be concise in your presentation to the committee, and maybe the barristers might be able to just sum up on your behalf. The hearing will then conclude. The subcommittee will deliberate in private with the legal advisor and the clerk present. Notification of the subcommittee's decision will be given within the period of 5 working days, beginning with the day or the last day on which the hearing was held. The notification of decision will include information about the right of appeal as appropriate. I will now ask all parties to confirm agreement on the proposed procedure or make representations. And rather than go through all that list again, if there are anybody who's not happy with those procedures, can you please make yourself known now? No? Okay, thank you. Right, so please may I remind all parties speaking not to repeat the information which they have already given in writing, but to expand on their written representations. I can confirm that the subcommittee has read through all the papers, and very lengthy they are too, including all supplementary bundles. All questions are being asked through the chair, and there will be no cross-examination of parties. I'd also like to remind all parties that this is not a court of law, but a licensing subcommittee convened under the Licensing Act 2003 to determine the review of the application that is before us today. Tanya, can you present the report, please?
Yes, thank you, Chair. So this review application has been submitted by Mudderford Sandbank Beach Hut Association, who are the applicant, under Section 51 of the Licensing Act 2003 in relation to the premises licence held by the beach house at Mudderford Sandbank. The grounds for review relate to the prevention of public nuisance, public safety and protection of children from harm licensing objectives. The applicants state that the premises have changed the operating model, resulting in increased noise from music and football, littering, public drinking, and concerns over public safety due to high visitor numbers and off sales of alcohol. They also raised issues regarding children's exposure to alcohol-related activities. It is claimed that the premises now operate more like an open-air festival-style venue, negatively affecting beach hut owners and residents. The applicants seek to realign the premises operation with the licensing objectives and have proposed amendments to the licence conditions, which is set within their application. The premises have held a licence since 2005, transferred to the current licence holder, Mace Made Limited, in 2009. Following a fire in 2018, a temporary structure was installed and a minor variation was granted in 2019 to update the layout plan to reflect this new structure. During the consultation period for this review, 24 representations were received in support of the review from beach hut owners, and 1 representation was received in objection, supporting the premises. The applicants have also submitted personal impact statements from beach hut owners.
In response, the Director of Maid Limited and the Operations Manager have provided witness statements refuting the claims and addressing the points raised. Supporting evidence includes a petition with 573 signatures and emails from beach hut owners in favour of the premises. I must highlight to members an error in the original report. An incomplete version of the petition was included at Appendix 8. Members will note that a revised version containing both the original and completed petition was published yesterday, and I trust members have had sight of this updated document. Some submissions include video footage, which will be shown at members' instruction. No formal representations were received from responsible authorities. However, Environmental Health, Planning and Fire Authority provided comments. Members should note the Environmental Health Officer's reference to a planning application which has now been granted and which includes noise management conditions. While planning and licensing are separate regimes, guidance encourages alignment where appropriate to support licensing objectives. Both parties are represented by legal counsel, Mr. Gary Grant for the applicant and Mr. Gerald Guriet, KC for the premises licence holder. Their submissions have been circulated to members and include proposed conditions and responses. Mr. Guriet KC has advised of a correction on condition 17 in his annex, clarifying that deliveries should be permitted between 0800 and 1200 hours, reflecting the cafe's supplier schedule. He will address this further in his submission. To avoid repetition, I will leave it to both parties' legal representatives to expand on the application, the representations and supporting documents. Members are reminded that any powers exercised by them must be necessary and appropriate for the promotion of the licensing objectives and directed at the causes of concern which the application identifies once these have been established through the hearing. Thank you, Chair.
Thank you, Tanya. Members, do you have any questions for the officer at all?
No, Chair.
If I may, Chair, there was mention of environmental protection. Do we have a note of how many formal complaints or reports are there?
It's on the officer's response. I think she has been.
Thank you, Chair.
Thank you, Councillor Farquhar. Are there any questions at all for the licensing officer? Can I start with Mr. Grant? Do you have any questions?
Simply to clarify this, that there is a second licence that's not up for review, and that's known as an off-licence licence for what essentially is a takeaway shop. It's a red herring in this case because it relates to a premises that burnt down in the fire in 2018. Is that right, Ms. Jardine?
I have been advised so, yes. I'm not sure about it being burnt down. I only found that out recently. So, yes.
Thank you for that. Mr. Courier.
Mr. Grant, the skilled advocate, has slipped in a bit of advocacy in what should be a question. I don't think it's a red herring at all, but I do agree that the off-licence premises are no longer there. But I should be referring to the permission given in that off-licence in due course.
Thank you. Any questions from the floor at all for the officer? No? Thank you. In which case then, can I turn to the applicant, please, to address the committee?
Councillors, change is not always progress. And when the commercial transformation of a licensed venue, in this case, Mudderford Beach House Cafe on the sandbank, goes from what was an enclosed, sit-down, food-led restaurant cafe into a packed, open-air, music and alcohol-led beach party venue with DJs, and that begins to wildly damage what is of true and lasting value on the sandbank, a very special location, then it is time for this council, this licensing subcommittee, as the custodians of the sandbank and as the licensing authority promoting the licensing objectives, to step in and to safeguard the sandbank for future generations, or else all that is of true value will be lost. Just a few years ago, it used to be, the representors state in your pack, that the dominant noise heard on the sandbank was birdsong, and I quote, the soft hum of boat noise on the English Channel. It is now music blaring out of the cafe and drunken revellers served takeaway alcohol from the cafe and one of its various hatches. On this licence review, the council has both the power and the opportunity to do something about that. It would fulfil the purpose of licence reviews, which the guidance to the Licensing Act tells us, I quote, represent a key protection for the community where problems associated with the licensing objectives occur after the grant or variation of the premises licence. And for your lawyers, legal advisors, note it's paragraph 11.1 of the 182 guidance. Now, in order to achieve just that aim, taking appropriate and proportionate steps in order to promote the objectives, we, the association, make a number of reasoned proposals to achieve that objective, which at the end of this submission, I will go through in detail and explain why we say they are both appropriate and proportionate measures. Contrary to suggestions spread by the licence holders or others on their behalf, suggestions which have resulted in a large petition and other supporters on their behalf, there has never been a request for the applicant to simply revoke the premises licence or to seek to close the cafe. Instead, the proposals both in the review and what I state today is this, that there are measures less than revocation, which if taken will avoid the need to close a popular venue. Instead of closing the venue, something we do not seek, the more modest and reasonable request of the association is that the licence is modified to ensure that the cafe operates as it has done for most of its existence since at least the 1950s, but in a style that is in harmony with the sandbank, its residents and visitors alike, instead of continuing along its path, which is ruining the sandbank and the enjoyment of the premises of the residents who live there. You will know, of course, as an experienced subcommittee, that the primary duty is to promote the licensing objectives, not maximise the profits of the cafe for Mr. Kim Slater and his family who own it. Now, I have set out detailed written submissions in the main supplementary pack, and you'll find those submissions beginning at pages 3, going through to 18, together with our detailed proposals, which I'll run through in a moment, which you'll find in the same pack just after my submissions, on the pages 19 through to 24. And I'm going to speak to those submissions, and then I'm going to call briefly on my clients, Mr. Darren Pidwell, who's the chairman of the association, and Claire Bath, who's the deputy chairman, just to briefly allow them to speak to you about their experiences of life on the sandbank. And the way I propose to deal with these oral submissions is to take these points in this order. I'm hoping that if I'm allowed to expand on these points, it will cover much of the ground that some, but not all, of the other representatives wish to cover. So if I'm allowed to speak a little bit longer, I'm hoping long term it will shorten proceedings today. What I intend to do is firstly just to address the sandbank, the location, what are we talking about, why is it special? And then I'm going to explain the role of the association, who I represent, the applicant for the review. I will deal with the situation before the devastating fire that destroyed the original cafe in 2018, what has happened since 2018, and the impact that's had on those who live on the sandbank. I will deal with the objectors to the review, so the supporters of the cafe. I will deal with the licence holder's attitude and approach to legal constraints to date, and then briefly touch upon matters of statement in your statement of licensing policy relevant to today, and then I will go through in detail the proposals we put before you. Before I embark on that, could I immediately, and I suspect I do this on behalf of all parties, acknowledge and thank the assistance and conspicuous professionalism of your licensing officer, Tanya Jardim, who has been emailing day and night over recent weeks in order to prepare matters for today. So she has our thanks for that, and it enables us to have a much smoother hearing than would otherwise have taken place. The sandbank itself is described on the Visit Dorset tourism website as a unique and beautiful sandspit which adjoins the ancient headland of Hengistbury Head and forms a natural barrier between Christchurch Harbour and the open sea. The area is designated a site of nature conservation interest. Now, this council, BCP Council, owns the land on which the cafe sits. It is the landlord. So you are somewhat sitting in a different role to that, obviously, of a landlord, but in your quasi-judicial capacity as a licensing subcommittee. Now, the council cares for the sandbank and has set out its management plans for the sandbank in great detail in a document called the Mudderford Sandbank Management Plan. The most recent plan runs from 2014 to 2024, but it remains the most recent plan. Now, could I please immediately ask you to turn to the relevant passage of that plan? You'll find it in there's been lots of supplements, but the main supplemental pack in this case is the first one that runs to 178 pages. So could I ask you please to bring up on your laptops? I'm afraid I'm a dinosaur and I have the paper version, which I apologise, but you'll find that plan beginning at page 71 of the main supplemental pack. I'll pause until you find that on your computers. You okay? So page 70 is the front cover. You have a picture of the very beautiful sandbank there. And if you please turn within that management plan to page 87, that's Agenda Pack 87. You should have a heading 1.8, Tourism and Marketing. I'm just going to read the relevant passages here, and it's worth citing at length, but I hope of relevance. And I begin at the second paragraph. For most of this century, Mudderford Sandbank has provided a tourist attraction to Christchurch by its very nature of remoteness and inaccessibility. Visitors to the sandbank have always enjoyed the feeling of being away from it all in a tranquil environment with no intrusions from modern living. The sandbank is unusual in tourism terms in the sense that many of the visitors who stay in the beach huts are locals holidaying in their own town, simply to escape the stresses of modern life. Very few destinations find such tourism economic benefit from their own residents. The sandbank is something of a hidden gem in that visitors from outside the area will only generally find the sandbank by accident or recommendation. The council does not actively promote the sandbank as it does its other beaches, or allow commercial programme makers access if the location will be disclosed so as to preserve the tranquil environment of the area. In tourism publications, the council does describe the sandbank, but stresses that access is not as straightforward as for other beaches, and it is likely that a visitor to the area would choose the beaches from Avon to Highcliffe in preference. There is no doubt that whilst the popularity of the sandbank could be increased, visitor levels should be kept at present levels, and this of course is 2014, to maintain sustainability. In tourism terms, there are too many examples of fragile sites that have been destroyed through sheer pressure of numbers and poor visitor management, and it is hoped that this management plan will work to assure the sandbank's unique environment is preserved. Those hopes were being promoted between 2014, when this plan was created and published, and 2018, until the fire that destroyed the original cafe. Since the cafe reopened in a very different style, those hopes are not being fulfilled. I want to say a word about my client, the association. There have been resident beach huts on this sandbank from, we believe, 1931. There are now 346 huts. There has been 348. I think we've lost a couple. There are not 400 plus as described in the licence holder's evidence. From the 1st of March to the 31st of October each year, residents are permitted by the terms of their own licences issued by the council to reside, to sleep in those huts. And that is what makes them unique from other beach huts up and down the country. If you still have the management plan up, you'll see that on page 87, that the council's own assessment is that during this peak seasons, 1st of March to the 31st of October, there are more than 1,000 residents sleeping in huts on a daily basis on the sandbank. So this is a large residential population from the 1st of March to the 31st of October. Outside those dates, so 1st of November through to the end of February, sleeping in the huts are not permitted, but the residents do use it during the day, not in the same numbers as during peak season, but they are still used. Now, some of these residential huts are just a few metres away from the cafe. Others are hundreds of metres away. And the association I represents 92% of the resident hut owners. The pursuit of this review followed votes of the association at annual general meetings in both October the 2024 and October 2025. The association does not, contrary to the mischaracterization by the licence holder in their paperwork, represent only a minority of beach hut residents. It represents the overwhelming number of hut residents, and there are barely a handful of hut residents out of the 346 now existing who have come out in support of the licence holder in this review. Now, in this review, you've heard there are 25 formal representations. Only one formal representation is in favour of the licence holder. The other 24 come in all but one case from resident hut owners and are in favour of this review and what we are asking for. Now, it's been queried in the licence holders' papers, well, there are 340 odd huts. Why aren't there more representations in support of this review? There are two principal reasons why there are not more. One, the association represents the residents, so most of the hut residents who support this review decided it wasn't necessary to simply duplicate the work their representative association is already doing. And two, and I'm sorry to have to raise this, but there have been well-grounded fears among our members of recriminations from the licence holder, in particular Mr. Slater, Kim Slater, who is a high-profile and influential figure in the area, who owns 3 hospitality venues in the area, and they fear that if they put their head above the parapet, they will face those recriminations. Mr. Slater has been known on numerous occasions to ban residents from his 3 premises who raise a word against him or raise complaints against him. There was, with even more regret, a very recent example of this that's set out in my written submissions on the 31st of October 2025, less than 2 weeks ago, when the deputy chair of the association, Mrs. Claire Bath, was attending the Boathouse in Christchurch, which is another premises run and owned by Mr. Slater. She was there with friends having a quiet drink, was confronted by Mr. Slater, was told that she's not welcome in his premises or indeed the beach house, and together with one of his door supervisors, ordered her to leave the premises. It is exactly that sort of behaviour that has led to many residents refusing to put pen to paper in this review, but they know they are being represented by the association here today. I would add that that unfortunate incident in October 2025 at the Boathouse has not been gainsaid by any of the recent written submissions of the licence holder. I want to deal now with the situation before the 2018 fire, the sort of situation we would like the licence through modification to move back towards. This premises, as its name suggests, was run as a restaurant cafe. It was food-led, with alcohol sold together with table service meals. It was a pint of beer, it was a bottle of wine, together with sit-down meals where people were served by waiter or waitress, and it had a capacity of 120 covers. There was a minimal takeaway offering of either food or drink. It amounted to a small hatch. It was a pizza counter. Previously, there were occasional live music events. But because before the fire, this was within a contained building with a roof, there was little to no music escape. And because the customers of the cafe were seated inside, there was little to no people disturbance outside the premises. And the existing premises license is consistent with that food-led restaurant use. And I'm going to please turn to the relevant conditions of their license because they're relevant to your decision today. You'll find the current license in the main agenda pack at between pages 35 to 43. If I could ask you please to bring that up. You will see the hours permitted on the page 35. The license only authorises 2 activities. One is late night refreshment. That, as you know, is hot food and hot drink after 11 p.m. And 2 is the supply of alcohol. Now, the late night refreshment hours run to midnight 30 Monday through to Saturday and half an hour earlier on Sunday. Provision of late night refreshments to take place indoors and outdoors, with some non-standard timings, Good Friday and Christmas Day. Supply of alcohol, Monday through to Saturday is a terminal hour of midnight, Sunday 11:30 at night, with an extension on New Year's Eve to allow 24-hour operating. The license permits on and off sales. You will note that unusually there isn't actually a closing time on that license. Now, if I can take you please to the relevant conditions. If you please turn to page 40. There is a condition entitled at 1.20, about 2/3 of the way down, that has a title, Condition on Supper Hours Certificate attached as part of conversion application under transitional grandfather rights. I'll come back to what that means in a moment. And 1.20 reads as follows. The premises are structurally adapted and bona fide used for the purpose of habitually providing for the accommodation of persons frequenting the premises substantial refreshment to which the sale and supply of intoxicating liquor is ancillary. Now, this is important for the purposes of the review. I do not dispute the origins of that condition as set out in Mr. Gurria's written submissions. Supper hours certificates traditionally applied to an extension of hours under the old licensing regime. But, and it's a big but, that restriction on their use has not transferred onto the current license. So you are entitled to look at the plain words of the condition on the license and ask, do they only apply for a limited period or do they apply for all of the hours? And when fairly looked at, those words plainly apply to the whole license and are not limited to any particular time period. Now, substantial refreshment in old money meant substantial meals. And so what you have on that license is effectively what we would now, under modern parlance, call a restaurant condition, where alcohol may only be sold ancillary to substantial table meals. Now, it might be said, well, that's not fair because that's not what supper hours certificates used to mean under the old 1964 Act and similar legislation. But the point is this, that was the license that Mr. Slater inherited. And if he didn't wish to comply, he had a perfect right to come before you to vary that condition, to remove it, or to modify it. And the fact that he did not see the need to modify what is effectively a restaurant condition is unsurprising. Because before the fire, pre-2018, that condition coincided with the principal style of operation of the cafe before it reopened in a new style. And the historical restaurant, not bar use of the cafe, is evidenced by a whole number of representations by hut owners, many of whom have lived there for decades, I think one since the 1960s, others who have worked there, there's one simply for your note at page 91 of the agenda papers, who confirmed this venue ran as a restaurant. It was table service meals. That was it. And any takeaway was a tiny part of the business, if anything. Mr. Kim Slater's own witness statement in these proceedings, and you don't need to turn it up, but for your note, it's in the main agenda pack at page 125, refers to developing the beach house into a, I quote, well-regarded coastal dining venue, known especially for its fresh, locally sourced seafood and family-friendly atmosphere. So that is Mr. Slater's claim as of today in his witness statement, that this is a dining venue renowned for its seafood and family-friendly atmosphere. We intend to propose modern conditions that puts Mr. Slater to his word. You will also notice, and this is of relevance to the review, that when I went through the authorised licensable activities, the licence did not and has never authorised what we now know as regulated entertainment. In other words, live or recorded music. How then can this premises lawfully provide live and recorded music as it now does and as you would have read about at great length in the representations? The answer is that from 2012 to 2014, there was some legislative changes that try to give flexibility to licensed premises to be able to offer live music at first. That was the Live Music Act 2012, and then extended to recorded music, even if it wasn't authorised on the licence. That was the fruition of some sterling work by Fergal Sharkey, if you remember him, who used to run British Music and led a campaign to try and open up licensed premises to more music. And that is, I'll call it the exemption, the regulated exemption, and that means that from 8 a.m. to 11 p.m, any premises that has a alcohol licence is also entitled by that exemption to offer regulated entertainment. However, the government recognised that in offering that flexibility, there was the real prospect of that flexibility being abused by operators if it leads to a nuisance to local residents. And so the power is contained within the Licensing Act to remove that exemption. In other words, and that's what we ask you to do. And your learned legal advisor is aware of the statutory procedure. It's through section 177 big A of the Licensing Act. And it simply requires you to indicate that we remove that exemption. And all that would mean is that you affirm that the licence should only authorise what it does on the face of the licence, supply of alcohol and late night refreshment, but is no longer to take advantage of the exemption for regulated entertainment. And the reasons why will become obvious when I summarise the supporters of this review's concerns and complaints. So I'm going to move on now to the position after the fire. You'll notice that throughout the representation, there is no cause of complaint from any of the residents I represent to how the premises was being operated before the fire, as the sit-down restaurant with minimal takeaway, if any. In fact, that was a cafe, also run by Mr. Slater, that was welcomed by the community and frequented by them. Now, there was a revolution in impact post the 2018 fire, because for understandable reasons, Mr. Slater wanted to get up and running as soon as possible after the fire. He speaks in his statement, and we believe this is right, about how the council, which was the freeholder, hadn't insured the building for sufficient money to rebuild a like for like. In other words, to rebuild a proper self-contained building with a roof and with solid walls. So as a temporary measure, some container units were put up. And from there were serving hatches for food and alcohol. And you can see, in fact, if you look at the plan attached to the licence, in fact, I'm going to run through a photo that will be better, what happened after the opening. If you please look in the supplemental pack and turn to some photographs on page 25 onwards, and I'll pause till you bring those up. It makes it a lot clearer, the differences between the before the fire and after the fire operation. I'll wait for your judicial nods before I move on. So it's main agenda pack, page 25. Councillor, it should look like that.
Yes, my colleague has it here, but we're using different software. Using the modular software. It would appear that I have a hard copy here. No, that's fine, thanks.
So you'll see on page 25, this is pre the fire. And you'll see the beach house in the middle of the top photo with the beach huts surrounding it. To the left, to the right, behind. And you'll see the inside set out as a proper restaurant. And you'll see that there is a roof to that beach house enclosing the whole of the beach house. It was a self-contained unit. Over the page is other perspectives of the pre-fire. And then if you turn to page 27, you'll see what I put in inverted commas, the temporary structure set up immediately after the 2018 fire. And that's that photograph. And you will see what's happened. You'll see those sort of reddish, pinkish, as they've come out on my printer, containers, that's essentially the serving hatches. And you'll see the open space with no more than fabric canopies covering a part of it. And that is still the position as of today,
Here's what I found.
some 7 years later. So you go from a self-contained unit with a roof to an open-air structure. Yet the same licence, say for an altered plan, applies to this temporary open-air structure now, the one that's before you, than previously applied to a self-contained unit, which is why we say the current licence is wholly unfit for purpose, and because it doesn't contain the measures it needs to, that is what has led to to the problems that brings this review before you. You will see, while we're on the photos, what the operation now looks like. And if you please go from page 28 and look through those photos right through to 32. You will see that this is now primarily an outdoor takeaway food and drink enterprise. A world away from what it was and the premises license before you was designed to control. You will also see that this is no coincidence, that this sprawling takeaway offer that it now is, in contrast to pre-fire, has been promoted and pursued by the license holder through social media. So if you look, please, at page 32 from the bottom, you'll start to see, you should have that page before you. The social media promotion of the license holder, which has been wildly successful for them. You'll see, and in the middle, you'll have the extract from the Sandbank Management Plan that says the council's objective, that the council does not actively promote the sandbank as it does its other beaches, or allow commercial programme makers access if the location will be disclosed so as to preserve the tranquil environment of the area. Well, the council doesn't, but Mr. Slater and the licence holder have filled that gap, because they have. And you'll see the rum and reggae afternoon parties at the beach. You'll see social media posts boasting of open-air festival-style food and drinks. You'll see PIMS counters. You will see burger takeaway joints at 34. You'll see Kev Jackson's party band tickets, £28 per person. You'll see curry nights with live bands. You'll see end of summer parties. You'll see on page 35 crowds of people outside eating or drinking.
Mr. Grant,
Yes.
are you able to tell us exactly what the issue is here, rather than just looking at the photograph?
Certainly.
What, in terms of undermining the licensing objective?
Yes. This use of the premises has directly led to public nuisance suffered by the residents. And it's not coincidental or accidental, it's positively sought by the licence holder. If you turn, please, to page 40,
Legal advisor.
Just to keep us on track, there's a lot of information. You're going through the pictures, so is what you're claiming, for example, on page 31, that is there public nuisance occurring while those people are sitting on those benches? That's what,
the representations talk about just that, yes.
okay, so that's what your claim is?
It's not my claim, it's what the representations are, yeah.
Yeah, okay,
Yes.
thank you.
Page 40. You should have a heading that says social media live music. You'll see this is social media posts by the Beach House Mudderford. We have live music every single weekend throughout summer next weekend. Saturdays, we welcome acoustic musicians playing between 1 and 4. Every Sunday, DJ Neil Maloney plays chill Ibiza tunes, the ideal soundtrack of the summer. You have DJs on page 41. You have live musicians on 42 and 43. and so on and so on. You'll see the primary marketing of alcohol from the premises at pages 48 and 49 and 50 and 51. You'll see on page 54 a post advertising an open air festival at the premises. So this is 54 and the text reads, it talks about the previous pandemic, it talks about the fire, and it says remaining open throughout the winters and through a pandemic, when we were allowed to be open, of course, we created an open air festival style food and drink takeaway, including a retro style burger van, stone baked pizza kitchen, paella seafood and salad counter, beach bar, as well as our essential beach shop and kiosk. Now I'll pause there just to make this obvious point. The contrast between what the operation is now and before could not be starker. But I repeat, the license that simply tried to control a previous restaurant is the one that now fails to control the existing operation, and that is directly leading to public nuisance being suffered by residents of the Peach Huts. Now, you'll remember me putting the words temporary in inverted commas. The residents understood that this had been a devastating fire, both for Mr. Slater and for other users and residents of the sandbank who liked and frequented the restaurant. And so they have shown great toleration towards the license holder to try and get the restaurant refinanced and rebuilt as it was before, which is what they wanted. That toleration of temporary structure and all the consequences that flowed from it, namely the nuisance from crowds of people, drinking, and so on, and the music escape that disturbed them in their homes, that toleration has now gone on for 7 years. It was hoped, because there were repeated promises, that the original restaurant would be rebuilt by the council with the assistance of the license holder. There have been many obstacles and hurdles, not least the fact that the council did not have the money because it hadn't insured the venue sufficiently to rebuild it. And it has become apparent that despite promises that this was temporary, and despite the toleration shown by the association and its members not to complain about all the noise and disturbance, because it was thought there was light at the end of the tunnel, there is no light at the end of the tunnel. And we know that because the most recent planning application, approved just a few weeks ago, was also for an open-air structure. So that is why it is crucial that the license is modified to reflect the new style of operation, or even better, to reverse that sort of operation. If I can turn you, please, to what Mr. Slater and the license holder were telling residents, were promising residents in recent planning applications, not the immediate ones, but ones through 2020, 2021. In these supplementary papers, please turn, if you would, to page 69, and this is a mission statement. So that is a mission statement. It was created by the license holder in order to support a license application. And you need only read the top 3 lines of that. Leave only footprints. The only sound is that of the waves breaking. Create only good times. That was the promise by the license holder to the residents. Just bear with me. And that's what will come. And this was issued, I think, in 2020, 2021. Is that right?
Yeah, 22.
2022. Compare that promise to residents, and no doubt you'll be given more promises today by the licence holder. Compare that, please, to what I've just read you from the photographs, just for your reference, page 68 of the main agenda papers, the social media posts. We created an open-air festival-style food and drink takeaway. So despite repeated promises to change, those promises have repeatedly remained unfulfilled. And since the fire, what has happened, and you perhaps can't blame him, he is a man of commerce, the licence holder has taken very full commercial advantage, regardless of the consequences to residents. And he will continue to do so unless this subcommittee takes appropriate steps. The temporary structure you see before you that was meant to expire, I think, in the coming months, if not year, there is now an application to extend the temporary structure you see in the photos by another 2 years, which means the temporary structure would have lasted 7 years. And that is what residents have had to tolerate until now. There are some videos that I know you're going to see in private session after my representation. Like any video, they provide snapshots. You may find more assistant by reading, as I know you would have done with care, the real life experience of the residents who have made representations in support of this review. 24 of them, plus 8 anonymous ones that you'll find in your main agenda papers between pages 53 and 92. Additionally, you'll find 8 personal impact statements. Those have been anonymised, and that's for the fears of recrimination I dealt with earlier. You'll find those at pages 95 to 104 of the main agenda pack. And before I just summarise, and I will do it in summary form, what those representors complain of, what their real life experience is, there is a suggestion that, well, a lack of complaints to environmental health noise team is something you should be looking at. And can I address that head on? I explained to you the toleration that the members of the association showed towards the licence holder on the basis it was temporary. And because of that toleration, despite them frequently being disturbed, and you will hear from them later on in this hearing, despite that, they held off complaining left, right and centre to anyone because they wanted to give the licence holder a chance to improve. There were some complaints, but nowhere near the sort of number that you would have thought would come because of the extent of the disturbances. And that's the reason. The reason is my clients were not complaining left, right and centre at every small issue. They were trying to tolerate it until the temporary structure was abandoned and a self-contained unit was built. We now know that will not happen and it may never happen, which is why they look to you for relief. So what do the residents say? Well, I'll just summarise those in bullet forms. Multiple residents describe excessive noise from amplified music, from DJs and crowds, often late into the evening. Children who reside in the huts and adults are either woken or kept awake by the noise of the customers or the music coming from the huts, or customers, often drink-filled, who walk along the beach in between the huts. The peaceful, family-friendly character of the sandbank, representatives say, have been replaced by a festival-like or pub atmosphere. There are complaints of foul language, drunkenness, disturbance, spilling into nearby beach hut areas. There are no toilet facilities in this temporary cafe. And so all of the revellers, the customers, use the public toilets, the ones used by the beach hut residents, and there are only 3 men, 3 male and 3 female toilets. And as a result, there are queues, the toilets are left in a terrible state, and too often the representors speak in their representations of customers of the beach house urinating around the beach huts. Imagine that, not least when you have children in those beach huts. As a result of the massive intensification of use of the cafe, which has been sought by the license holder, and that's the purpose of showing you the social media posts, there is an excessive number of commercial delivery vehicles, large vehicles at all times, often carrying beer kegs, which make a terrible noise, a racket, during unsociable hours. They sometimes reverse along the harbour walkway, making it impossible for residents to use it. Alcohol is sold and consumed freely outside and not just with meals or inside the premises. And there has been this shift, nearly all the representatives say, from this food-led restaurant to a drinking venue, with patrons wandering along the beach drinking. The expansion of the cafe area, by which I mean both the licensed area as well as where its customers congregate, has gone massively beyond its former footprint, with tables spilling onto the foreshore and pathways. Single-use plastics and litter is strewn all over the beach and around resident huts. Children exposed to loud, drunken behaviour and disorder. And the long-term hut owners describe in their representations the loss of tranquility, the rowdy behaviour and the diminished enjoyment of their huts. And they will speak more eloquently to you from their own voices later today. In response, there is a single, as I say, formal representation in support of the cafe, but using their social media, there is a petition that the cafe operators put before you, signed by over 500 people. Overwhelmingly, that petition is signed by people who do not live on the sandbank and so are not the ones being disturbed in their beach homes. They have fun, sometimes too much fun, and then they return to the peace and quiet of their homes. The members of the association I represent do not have that luxury. There are a handful, but no more, of hut residents who have offered their support to the licence holder. They are close friends of Mr. Kim Slater. At least 2 of them go away on holiday with him, I'm informed, or they share business interests with him, or they live a long distance away and so out of earshot. Of the most recent ones, the nearest is 90 metres away. Martin Stewart makes not a representation, a supporting letter. He lives 175 metres away and is a friend who goes away on holiday. There is one, Will Everly, who served an email on us recently, who lives 10 metres away, but it's clear from his email that he believes what's on stake today is closing the premises, and that's why he's intervened. That is not what we're asking for. There is one, Mr. Simon Vivian, who once again is a very close friend of Mr. Kim Slater, and I understand shares ownership of a boat with him. Now, the issue here is not the popularity of the cafe. Undoubtedly, it's popular. It's extremely popular. That is why there are the crowds. That is why so many people have signed a petition. That is not the issue, whether it's popular. The issue is whether the style of operation and the sheer massive increase in numbers that are attending are undermining the licensing objectives. And the really primary objective that it's raised here is the prevention of public nuisance, and whether that popularity should deny the rights of residents and other users of the sandbank to enjoy what makes it special, its tranquil beauty, which is also the council's policy as expressed in the management plan. Now, what is the licence holder's attitude and approach to the legal constraints? I want to deal with the lease, and we've included this, and I want to make an immediate correction to my written submissions. Now, in my written submissions, at paragraphs 49, A and B, I put in italics, delivery restriction conditions and waste management conditions. Can you strike through those? I have mistakenly converted what my clients believed to be what was appropriate and general for other premises in the area. I mistakenly took those to be conditions in the lease. They're not, and I apologise for that. Page 14 of the supplementary papers. So page 14 of the supplementary papers, those are my written submissions. Do you have those, Ms. Cole? I do, yes. Yes. So please, 49 A and B, please strike through those because those do not, they are not a quote from the lease terms. What is a quote correctly from the lease terms is, if you turn to the lease, this deals with the duty on the beach house as the leaseholder. If you turn, please, to page 142 of the supplementary page, this is from the lease. I'll wait until you've brought that up. So this is page 142 of the supplementary pack. So 4.16 deals, this is from the lease, and obviously the lease agreement is with the council. 4.16.1, the tenant must not do anything on the premises or allow anything to remain on them that may or be or become a cause or cause a nuisance, annoyance, disturbance, inconvenience, injury or damage to the council or its tenants or the owners or occupiers of any adjoining or neighbouring premises, including the beach huts or other persons lawfully using Mudderford Sandbank. And then just over the page at 4.16.9, the tenant must comply with the council's management plan for Mudderford Sandbank so far as it affects the premises. And we've already turned to that previously. When you read the representations from the residents, can it be said, can it seriously be claimed that the licence holder is not in absolute breach of that condition? When it comes to planning, and I simply look at this, recognising planning and licensing are different regimes. Sorry, is there, can I say this? I've put out in written submissions, and this will goes to the ability or willingness of the licence holder to comply with regulation of any sort. That during the planning, most recent planning application, I cite this in paragraph 50 of my written submissions, that there are not one but two ongoing planning enforcement issues noted by your planning officers, and I've extracted that from the planning report for the most recent application. For the Ms. Cole's note, it's paragraph 50 of my written submissions. And that is for allegations of unauthorised use of picnic tables as additional seating for the customers of the cafe. And the other is the unauthorised use of the beach shop as a hot food takeaway instead of a shop. So I raise those simply to indicate that this is not a licence holder you can implicitly trust to comply with every legal obligation upon him. I want to deal now with responsible authorities, and I have no doubt it will be pointed out to you, well, the authorities, environmental health, the police do not offer representation in support. It does not surprise the members of the association I represent. Your noise officers are extraordinarily busy, and they are too few in number. And it is not easy to come out and respond to a noise complaint on Mudderford Sandbank. It is deliberately inaccessible. That is why, among the other reasons I've cited, there are so few noise complaints, because the residents know there's nothing the noise officers can do. They can't get there in quick time to respond. And that is why, with very little monitoring of the premises, why the environmental health simply does not have the evidential base to make a representation supporting this review. You, on the other hand, are in a very different position, because you have seen all of the representations from the residents as to the very real public nuisance they are suffering. Now, it may be submitted to you by the licence holder that we've just had a new planning application granted. Well, that new planning application does not relate to the premises as it is now built. It relates to a different structure. And so you need, when you consider this licence, to look at the build situation as it is now. If the new build permitted by the new planning permission actually ever gets done, then the licence holder will have to come back and apply for a new application. And I believe that would be their intention. So please don't look at the planning committee's decision to grant it as giving the thumbs up to what's going on at the moment under the existing premises. They were dealing with what a new premises and how that should be controlled. But that's not your role. What is noticeable, having watched the video of the planning committee, and I posted the hyperlink to it, is that on repeated occasions, different members of the planning committee that granted planning permission said that the controls, the operating controls, are a matter for the licensing subcommittee at today's review, because it was raised. So please do not think that somehow your task today has been already decided upon or delegated to your planning colleagues. It hasn't. In fact, the reverse is the situation. They would put, if I can put it this way, this hot potato back into your hands to deal with. In my written submissions, and I'm nearing the end, you'll be delighted to hear, at paragraph 59, I set out the relevant policies within your statement of licensing policy. And all of those policies, I say it's 59 of my written submission, talks about the, I'll read short, but it's at page 17 of the supplemental bundle. Your policy talks about encouraging the responsible promotion of licensed activity in the interests of its residents and visitors. And then the licensing authority is mindful of the potential for noise nuisance from amplified sound and live music. Where there are representations on this issue, the authority would normally impose appropriate conditions on variations or new licenses, or refuse consent if necessary for the promotion of the objective. Conditions to prevent noise nuisance can be imposed. Other policy elements where applicants propose to provide seating, tables or other facilities in any outdoor area, whether covered or not, applicants expected to demonstrate in their operating schedule, read short, that suitable and sufficient measures will be in place. Now those of course apply to prevent nuisance, those apply to new applications, but the principle holds good for today's application too. That now brings us to the proposals, and I'm going to go through those and explain why we say they are needed in order to promote the objectives, in particular, preventing public nuisance. Now, I think what may be of most assistance is to turn to Annex A of my written submissions, which is in the supplemental pack at page 19. Have you been able to bring those up before you? So this is cutting to, after a very long place, to what we are asking for, and I'll explain why. Firstly, hours. As you know, there's no closing time. As you also know, this is a premises that is operating until late into the night, right next to residents, some with sleeping children. And I should say, as I have in my submissions, that this is not necessarily a take all or leave all collection of conditions. They are conditions from which you can select what you think are appropriate and proportionate to prevent public nuisance, which is the principal licensing objective engaged. We suggest you should very seriously consider reducing the current late hours, remember midnight, midnight 30, in premises that operate next to residents. And we have suggested that the authorised hour for the sale or supply of alcohol shall terminate at 21:30 hours, with a half-hour drinking up time until 10 p.m. And we say that a 10 p.m. cut-off for a premises that's caused enormous disturbance over years is not inappropriate when you're right next to and cheek by jowl beach huts, which are residential in nature for much of the year. 3, because you only need late night refreshment if you serve after 11 p.m, that's not required if you were to reduce the hours. And you should reduce the non-standard timings, 24 hours on New Year's Eve, for example. 5 deals with the removal of the exemption that allows this premises, but only in recent years, to provide live and recorded music. There is a wealth of evidence that that flexibility has directly led to a public nuisance. We ask you to remove it. So there will be no live or recorded music, save for background music, which is permitted in any event. 6 is a tidying up exercise. All of those old conditions, including the supper hour certificates and the various other conditions that relate to old legislation, you could usefully remove those to modernise the licence. And you'll remember the food condition, the one that on the face of it applies to all of the hours and all of the areas on this licence, that should be replaced by a modern restaurant condition of the type you'll be familiar with from other applications. And that is at point number 7. And that links the supply of alcohol to people seated taking a substantial table meal there and for consumption by such a person as ancillary to their meal. So that is a modern restaurant condition, and that simply gets us back to the principal style of operation that this cafe operated under without causing issues to residents. Condition number 9, we suggest you remove alcohol off sales from the premises in any event. And if you look at the plans attached to the licence, you will see that the red line, which delineates the area in which licensable activities can take place, includes the outside area. It's the one you saw on the overhead map, covered in part with a canopy. So people will be able to drink outside, but within the demise of the building, not sprawling all over the beach, which is what's happened since the fire. 10 is a proposed concession by way of allowing certain takeaway food and drink, but only insofar as it's ancillary to the use of the premises as a restaurant via the hatch. and is restricted, as before, to the sale of groceries, takeaway non-alcoholic drinks, ice cream and hot takeaway pizzas, consumption off the premises. And that removes what's happening at the moment, that this has become a takeaway bar and food premises, not the restaurant it was. Now, 11 will really only kick in if you refuse to remove the flexibility on regulated entertainment. So the first thing we say is music cannot be properly contained in an open air venue. Frankly, you don't need to be an acoustic expert to know that. If you're against me on that, the noise management plan condition would come in. There was one very similar but not identical to the one that I propose at numbers 11 and 12 that was imposed at the planning stage. Now, planning doesn't deal with nuisance in itself. It tends to deal with amenity of residents, but there are similar concepts. And there was a noise management plan. And that essentially said, and what I've done is under a separate document, I have submitted, and it might help if I hand that out now, it's already been circulated before, the condition your planning colleagues imposed. Can I give you a paper copy of that? Because I don't think it's found its way into a supplemental paper. I'll give you some copies. And there should be enough for Mrs. Cole as well. So I'm not going to go through all that, but I want you to know there are differences. I've suggested a slight variation on that noise management condition. Mr. Gurria has suggested another variation. It makes sense you've got the original to consult. But as I say, this only becomes relevant if you allow music to continue at this venue. But the primary difference in the version that the license holder produces is whereas both my alternative and the planning committee's condition say that this premises cannot operate until a noise management plan is in place, the license holder seeks to dilute that to say it cannot offer music after 5 p.m. until it's in place, which seems to suggest they would like the ability to create a noise nuisance before 5 p.m. You won't be surprised to hear that we resist that suggestion. Now, once again, that noise management plan condition imposed by your planning colleagues did not apply to the structure before you today. It only applies to a future structure if that is ever built. And until then, until that new structure is built, we've got to deal with what this is, which is almost entirely open air structure. And that is why we say no noise management plan is going to prevent the sort of nuisance that has arisen to date. Now, going back to the conditions, I've included my proposals for a noise management plan at 12. There are conditions at 13 that the doors and any large openings or canopies should be kept closed when music is being played after 9 p.m. I will concede immediately that that's unlikely to be successful when all you've got is serving hatches in containers and a canopy. But what I have done is this, that at 14, I've suggested that any music that emanates from the premises when measured at 1 metre from the nearest noise-sensitive facade, in other words, the beach huts, which to the rear of the premises, to the closest noise-sensitive facade, shall not result in any increase to the background noise level LA 90. That's, once again, this only kicks in if you allow music to continue at the venue despite it not being on the licence. And that would simply mean that if they insist on playing music, the nearest resident shouldn't be disturbed because it won't raise the music levels at their hut. 15 is to control smokers. 16 is a general condition that no noise generated on the premises or by its plant or equipment shall emanate from the premises. nor vibration transmitted through the structure which gives rise to a nuisance. That's a fairly standard condition on licence conditions. And then conditions 17 through to 19 deal with waste deliveries and litter. You'll see from the representation that the deliveries, particularly the beer kegs and all the heavy vehicles and the waste that's strewn all over the place, and you'll see photos of that, is causing a nuisance. And so we suggest that deliveries to the premises shall only take place between 8 a.m. and 10 a.m. There is a counter proposal by the licensing holder that should be between 8 a.m. and noon. We object to the extension past 10 a.m. because around noon is the busiest time. And so if you start getting, as described in the representations, large commercial delivery vehicles with scores of beer kegs coming through at noon, you're going to directly come into conflict with the people using the beach. Condition 18 is that no waste or recyclable materials, including bottles, shall be moved, removed from or placed in outside areas between 9 p.m. and 8 a.m. So in other words, no late night noise caused by bottles, bless you, or other waste should be put out on those antisocial hours. And 19 is a condition to put a duty on the licence holder to remove and prevent litter or waste arising from their customers. Conditions 18 through to 23 are all agreed, and so I don't need to go through those, but they are fairly standard conditions. Challenge 25, personal licence holder on duty, need for door supervisors to be risk assessed, and proper documentation that monitors what goes on to be kept at the premises. So that's what I've got to say with our proposals. And what I'm going to do briefly is ask Darren Pidwell and Claire Bath to deal with two specific matters.
If I could just interject there, sure. Mr. Grant. Do members have any questions for Mr. Grant at all at this stage before the representatives from the Beach House Association speak?
I do have one, if you please, Chair. It relates to the original agenda and it is referred to in the agenda supplement in answer. But I think it's important for the subcommittee to understand the applicant's view on, if you look at the original agenda, page 23, paragraph 20. I'll read it out for the benefit of those who are viewing online. The planning department advises that the conditions currently attached to the temporary planning permission of the structure, which is due to expire on the 31st of December, it does not include the year, which is 2025. Upon expiry, the operator will be required to cease use of temporary structures and submit a new licensing application once the CAF is rebuilt. At the time of writing, planning matters were on hold and no further comment could be provided. My question is this: for the applicant, in this particular case for the review, what effect would have if this planning department advisory for the temporary structures just expired on the 31st of December this year?
It won't, because there's an application to extend that by 2 years currently being considered by the council, and we anticipate it's going to be granted.
Who anticipates that it's going to be granted?
The association, and I expect the licence holder as well.
And if I may, Chair, when is that hearing going to be for the planning committee?
Is it even going to a hearing?
They haven't, no, they said it's delegated.
It's not going to go before a committee. It's been delegated to an officer's decision, I'm told.
Understood. Thank you very much, Chair.
Thank you, Mr. Grant. Sorry, beg your pardon. Can I at this stage ask, do you have any questions for Mr. Grant before I ask?
Yes, I've got one question, but can I quickly come in on the question of this temporary planning permission? It is going to a committee hearing in December. I haven't got a day in December, but it is not being decided by delegated authority. It's going before a committee.
It's news to me as well. Thank you for that.
It was just this, if I may, You said in relation to your proposed condition 19 about measures being in place to remove litter, you said there are scores of beer kegs around, and I just would like some help, please, on that. Is there a photograph that you would like me to look at showing scores of beer kegs?
There's no photograph,
Right.
but you'll see representations that you would have read.
Okay, thank you very much.
Give it that.
One of the videos shows the beer kegs being delivered.
That there were scores of beer kegs lying around.
Being delivered.
Oh, well. And
Thank you for that.
I'm going to call Mr. Pidwell to deal with one matter. He's the chairman of the association, and you'll know there's a lot of the licence holders' case is based on them only representing, it's said, a minority of residents. So, Mr. Pidwell, you're the chairman of the association. Can you explain to what extent the Beach Hut residents support your actions in this review?
Yes, morning, Chairman, members of the committee. Thank you. I think it's probably fair to say that for the last 7 years, the cafe, its rebuild, its operating model, as you can imagine, have taken up extensive airtime, both in my written communications to our members, our individual committee meetings, our annual general meetings, and indeed the numerous conversations and meetings that we've had with particularly Mr. Richard Slater as representative. And I think over that period of time, it's probably fair to say that we have become frustrated with the lack of progress. Primarily that is as a result of lack of funds and the council's inability to reach appropriate commercial terms with the tenant on what a rebuild facility might look like. And I think in October 24 at our annual general meeting, it was evident to us at that point that there had been multiple breaches over the years since the fire and the temporary setup being created in relation to planning, licensing and lease. But as Council has already expressed this morning, the majority of our members accepted that and lived with it on the basis of the fact that the site would be reinstated, it would return to its previous operating model. But unfortunately, it was evident that that was not going to happen. So we sought permission from our members to undertake a legal review. So let's really understand. I'm not a lawyer, I'm a retailer. But let's understand what the legal position is here, and let's see what we can actually do in our attempts to firstly get the site reinstated, but have an offer that was proportionate to the site and all of its controls and SSI statuses and all of the terms and conditions you've heard Council mention to you this morning and you've read within your papers. So we have extensively communicated with our members. Now, we tend to operate as a committee because primarily it's easier for us to deal with the BCP officers, your colleagues on a day-to-day basis for everything to come through the committee. Yeah? Your officers prefer us to be a single voice through primarily myself and Mrs. Bath as the representatives of the entire Beach Hut community, as opposed to 360 odd people trying to communicate with them. So that's the way it tends to operate. We have communicated extensively with our members. I have not had a single email from anybody who has disagreed. And in both those AGMs over the last couple of years, we have fully presented what we propose, the updates from our last meeting a few weeks ago, and we have unanimous support from that membership for the activity that we have taken. And I think that is why you have seen limited numbers of persons referred directly to you, because it is being done through the association, through Mrs. Bath and myself, And that's why we have the fortunate or unfortunate position of being sat here as the voice of those individuals today. So I think that simply would be my argument here. But we most definitely have the support of our members, and we most definitely want to see something return to the beach hut. This, as we've told you, this isn't about stopping the business, removing the licence. No, this is about having an appropriate and proportionate offer on the sandbank that works in harmony with everybody and is still a viable commercial operation, as it was for many years pre the fire. So that would be my submission to you. Thank you.
Thank you, Mr. Bidwell.
I'm just going to call on Mrs. Bath just to explain what the real human impact is of the cafe's current style of operation on you as a resident.
Thank you, Chair and members. I personally just want to say it's been very upsetting for all of us to have to come to this, because up until quite recently, we've tried to work in harmony with our neighbours, and the beach house is very much one of our neighbours. And a lot of the residents on Mudderford Sandbank don't want any confrontation. We go down to the beach to get away from confrontation and to have a peaceful time. And so it saddened me and most of my neighbours that it's kind of come to this, to get some sort of harmony back to how it used to be. Just to explain, I was going to read a speech, but actually I've been asked to just express how it is for us on the beach. My family have been on the beach for over 45 years, and so we've got quite good experience of what it's like now compared to how it was. Our beach hut is about 50 metres away from the cafe, and regularly we're woken up quite early in the morning when delivery vehicles come along. The shared footpath, it's not a road, it's a little tiny path which is shared by pedestrians and by delivery vehicles that come along. And because there's so many vehicles, they can't park in the one area designated for the service vehicles. They have to park along the harbour side. And then these vehicles obviously have reversing noises when they reverse back, because there's not space for them to have a turning circle, and so they're reversing back to allow one vehicle out, and at some point you'll see the video of what it's like. So that wakes us up with beer kegs being delivered and multiple vehicles delivering, because the demand that's been generated by the current operation is exponentially different to how it used to be. And so then we have the issue that music is generating a lot of these people to come down to the beach. The music promoted through social media, and the tenant has a very active social media campaign, which I don't decry. I think, you know, I'm for business to make money, but when it is in conflict with your neighbours who you try to work alongside, it doesn't work. And they've got 16,000 people on their social media. So their posts that go out promoting bands that are going to be on actually does have an effect on the number of people coming down. And then these people come down and are attracted by the music events, which happen regularly throughout the week, and are drawn, you know, to have alcohol and a good time. And I don't decry that. I don't mind anybody going for a drink and having fun. But when it's directly impacting neighbours, which are within about 4 metres of them, we don't have a choice. We don't have a choice if we're listening to the music, because we're listening to it. We don't have a choice whether we're involved in this festival takeaway setup, because we're there. That's where we're living. So I think, you know, the distinction has to be drawn between the people who've signed the petition, who've come down to have a good time, and I don't object to that at all. But when it has an impact on you as a resident, then I do object to it. And we've got young grandchildren, so I've got 3 grandchildren and 1 on the way. And they're playing in the sand outside our beach hut. And because they don't provide any toilets there, we've got people wandering along with pints of beer and glasses of wine, going down to the toilets, right past where the children are playing in the sand. And as the day goes on, they have more alcohol, and it's understandable. They're going to get a bit more lively. And we've seen people having arguments and the queues outside the loos are horrible. You know, there's only 3 ladies' loos for thousands of people coming down to their music events, and there are bathrooms. That's where we don't have a choice, you know, as to where we go to the loo. That's the only place we've got to go. So there's that. And then my daughter experienced taking her little 2-year-old across to the beach through some beach huts and bumped into somebody peeing between the huts who apologised, said, "Oh, I'm sorry, but the loos were so, you know, packed, I couldn't wait." And that's, you know, a 2-year-old witnessing that. It's just not nice. And it never was like this before. So I just want to explain, we worked in harmony as an organisation with the beach house, and it worked very well how it used to be. But they've kind of taken advantage of their current temporary setup, which now has been 7 years, and they've just applied for 2 more years. And it's for that reason that we as residents finally, and it has been a difficult decision to make because we want to be in harmony with our neighbours, of which they are. We want to, you know, draw it back into how it used to be and draw a line underneath what has been allowed for too long and we've put up with, because we've been promised every year it's going to be rebuilt, and we've accepted that. But now we realise actually it's probably not going to get rebuilt, and they want to carry on operating as they are. So I hope that gives a flavour of kind of what it's like day to day on the beach for us.
Thank you, Mrs. Bath. Before I move on, I've had a if you could just hold fire for a minute, please, Councillor. I've had a request from Mr. Peter Jones and Susie Bath if they can speak before we go to exempt session. So are members happy that these 2 representatives speak to us before we go to the... Yeah, thank you very much. Thank you.
I think Susie's just joined up.
Okay, so we go to Susanna on Teams, please. If you'd be kind enough to address the committee.
Yes, hi, can you hear me? Perfect. Well, I think a lot of the things that I was going to say have already been covered. So for the sake of brevity, I won't go over what's already been said. My mother is Claire Bath, so it's my 2-year-old who she's speaking about, and I have another baby on the way. I'm sorry I can't be there today to talk in person. Essentially, I grew up spending my summers at the beach, and it was a very peaceful time, and I have such happy memories, and it's really what I would want for my daughter and for my son, who's coming in February, to experience as well. When I was a teenager, I worked at the beach house for Kim, and I loved it. We had so much fun. It was a restaurant at the time, and I felt it was really in keeping with what the beach has to offer. Since the fire, as you've heard, it's changed a lot. And of course, you know, we were all hoping that it would be rebuilt, that things would return to the way they were. But actually what we've seen year on year is that it's become more and more festival-like and less like a restaurant. And the issue I have with it is, as my daughter's getting older, as she's running around, I don't feel that it's safe for her to play in the way that it used to be for me when I was a child. And it feels difficult as a parent to relax in the same way and enjoy the surroundings because of the nature of the business, the people who are coming down to visit the beach house, and what they're coming for. And what I'm worried about is actually this summer, my husband and I decided to go to Cornwall because we just want to go somewhere peaceful. We want to go somewhere that's unspoiled and properly relaxed. And sadly, I feel as though the beach house and Mudderford Sandspit is slipping away from being that, largely because of the way that the business is operating. And it, you know, our hut is 50 yards away, but I do really feel the change. And I just wanted to speak on behalf of myself and friends of mine who also have young children who aren't able to speak today because they're busy or working, to just put that view across, that I worry that if action is not taken, that it won't be such a place for families in the future. So yeah, thank you.
Thank you for your contribution, Susanna. Councillor Farquhar, did you want to answer your question now?
Yes. Thank you, Chair. This is a question for Mr. Pedwell. When you referred to the unanimous support that you had at recent AGMs, may I ask how many members of the association you got? How many were actually attending those AGMs, please?
So we currently represent 92% of the over 360 huts. So if my maths was right, it's 312 huts who we represent. Yes, we have, as I said, regular communication with them in annual general meetings. And that's the vehicle in which we receive their feedback, but also on the beach in the summer, I'm regularly stopped as I'm walking around doing whatever by members.
I think he's asking
how many people are at the AGM. So at the October AGM, I think we had over 80 members in attendance.
Thank you. So would I be correct in thinking that the AGM, sorry, the numbers on the association, you mentioned 312 huts that you represent.
Yes.
Is that 312 individuals, or is that 300? Is that number of individuals higher than 312 huts?
So it's 312 huts. Yeah, but obviously we communicate regularly with them. We keep them updated. We look for their support and, more importantly, their feedback and their representations to us.
Thank you, Chair. I've got a further question for Mrs. Bath, if that's possible.
Yes, of course.
Thank you. Mrs. Bath, thank you so much for coming and not reading a written statement. It's always very much beneficial to hear the lived experience for the impact at these subcommittee hearings. And I'm sorry for some of the comments which you may or may not have read on the petition which was raised. But my question is this. Can you just clarify how often you're allowed to stay overnight in the beach hut that you own, but also how often you actually do stay? So it's a two-part question. How often you are allowed to stay overnight, and how often you actually do stay, please?
Yeah, thank you. We're allowed to stay from the 1st of March through to the end of October. And when my family were growing up, we used to move down for the whole of the summer holidays. So we'd be down there for 6 weeks of the summer. Obviously, my family's grown up now, but so our family shape has changed somewhat. So we tend to share it between the family members. So they'll come down for a couple of weeks a year and stay, and I'll stay in between times whenever I can, because I'm only local. So you know, I'll go and stay down there. I wouldn't say there's a regular pattern to that. It's just whenever I feel like it, but quite frequently I'll be staying down there alongside a lot of my neighbours who've become friends. It's a proper community with people living down there.
So,
oh yeah, a lot of residents do move down there. Some residents have no proper home and they go off in the winter months and perhaps spend a few months in a rented place, but will actually live down in the beach huts because it's not a cheap place to live. It costs us quite a lot of money with our licence fee, and we pay council tax, so we are council taxpayers as well. So a lot of people take full advantage of it because a lot of them have had the huts for many, many generations. So the portrayal that we're all sort of wealthy individuals who've paid the crazy prices that recent huts have gone for sale doesn't represent the community. Most people have passed the hut down from generation to generation, a bit like my daughter saying how much she remembers it as a child growing up there, and so that is, you know, that it's cherished, and therefore the amount that it costs us to actually pay for our license is a lot, and therefore a lot of people alter their living accommodation to actually reflect the fact that they can stay down there for the majority of the summer.
thank you, Chair. May I just ask a follow-up question, and I've got a further question, if that's all right? Thank you, Mrs. Bath. You mentioned council tax. To help me with my understanding, you're referring to council tax on another property, or you're referring to council tax on the beach hut?
No, we all pay council tax. We are residents, and therefore we
on
pay.
The hut?
Yeah, yes. We pay council tax.
Okay, so my further question, you talked about witnessing public urination. Could you just clarify that the toilets which are used by any visitor or resident during those summer months. That the only toilet facilities that you have is the public ones.
Yeah, our huts don't have facilities. Some people have got porta potties that they might use at night, but that's our bathroom in effect, and so it is pretty overwhelmed, and it's been shut down on numerous occasions because the drainage from those toilets is through one sort of pipe that goes across the run and goes into Christchurch, because it used to belong to Christchurch Council, and so the toilets are regularly blocked because of overuse. And Renter Rod, I think, has a contract with the council to come down. And when that happens, there are other loo blocks along the beach, but this is the one that all the people from the beach house frequent because it's the closest.
Thank you, Chair. I won't delve into that anymore, but the impression which I get is that your association is covering 312 huts, and these 312 huts are using these single toilet facilities, except where they've got a portaloo, where they obviously have the empty of that. Can you just clarify, please?
So to answer that question, so there are 5 toilet blocks on the sandbank. The nearest one to the cafe is what we call block 3, and that is probably one of the larger blocks on there. And as I think council has already articulated, there are 3 cubicles in the ladies, plus obviously a urinal in the male toilet as well. As residents, I guess the only concession that we have is that in those toilet cubicles there is one which is locked, and as residents we have a key. That is it.
Thank you, Chair. I think Mrs. Bath wants to follow on from that.
Mrs. Bath?
Just one final thing. The residents' key does cause conflict as well, because we have to walk through the queue to get to the residents' toilet. And obviously you can imagine people desperate to go to the loo, and we're going in with our one key. You know, it causes quite a bit of conflict.
Understood.
One last question, you please, and probably Mr. Pedwell, I think would be best to answer. In the pack, it refers to the number of people sleeping, you know, in excess of 1,000 people, but that refers to a survey from 1995, some 30 years ago. Has the association done any surveys that relate to the actual usage in more recent years that people make of their beach huts with the change of the hours, or should I say the months, which they are allowed to sleep overnight at that particular site?
So have we done a survey of usage? The answer to that is no. I think what you'll find is that usage very much depends on time of year, summer holidays, school holiday periods, weekends, weather conditions. So it does vary. But I think what you do find is that there are a lot of people who regularly use their hut every single weekend, and for a few weeks in the summer period, and then go down there during the day, midweek, depending if they work or not. So it very much depends on, I think, individual personal circumstances. But I couldn't tell you today what the occupancy rate was, you know, month on month for the last X number of years. We don't monitor that, and there's no need to do so.
Thank you, Chair, very kind.
Thank you for that. Before I move on to Peter Jones, did you have any questions at all? Thank you very much.
Can we do comfort break? And then do comfort break.
What I propose to do is hear from Mr. Peter Jones, and then we'll have a comfort break after that before we watch the videos. Mr. Jones, would you like to come to the table, please?
Hello there. Thank you. Thank you for the opportunity to talk to you this morning, or this afternoon now. I'd actually had written a quite a detailed discussion document to discuss with you today, but obviously a lot of those points have already been mentioned. I think it's worth just emphasising that, you know, I'm very much in favour of a well-run establishment cafe on the sandbank. I have two children. Their ages are 9 and 5. We live just directly behind Mrs. Bath, and ultimately we go down to the beach house to have fun times, to get away from the world, to enjoy life to the maximum. And over the last few years, as what's been recorded today, there has been quite a few disturbances that we've been exposed to, and especially our 5-year-old and 9-year-old. Mainly, we've had urination outside our hut, a lot of noise. We've also had an incident where an individual tried to get into the premises, into the hut, i.e. tried to look around the hut when we were sitting at the front of the hut, which is obviously quite concerning regarding safety of our children. I think a major point that really hasn't been mentioned quite heavily today is the fact that there has been an issue with rats around near the hut. We had an incident which should be recorded with the local council and the licensing committee, but the licensors who actually, gives us these licenses every year to use the hut. That we had rats in our hut in December last year. A lot of this, we believe, and we were told by council officials, was as a result of increased rubbish near our locality. So this was quite a distressing time, especially for my wife and myself. We spent all of New Year's Eve actually cleaning up the hut. I must stress there was no food left in the hut during that winter period. I think going forward, the thing that we are concerned about is we have gone down there to enjoy life. To get away from the world. We pay a substantial licence fee. We want to give our children the best opportunities in life. We're very fortunate, we accept that. But we don't want that tranquility to be jeopardised. So, I could go through all the bits and pieces that Mrs. Bath and Mr. Piswell said, and obviously our barrister. But, just take this into account that it is impacting our fun time down there during the summer.
Thank you, Mr. Jones. Right, at this point, we'll break for a comfort break and we'll come back and restart at 1:30. Welcome back, everyone. I'm going to continue with the representations because I've had notification that a number of you wish to get away. You've got other appointments this afternoon. So if I could begin with Mr. Tony Webb, please. And can I just remind all parties speaking, please not to repeat the information that we've already been provided, but just to expand on your representations. Thank you.
Mr. Chairman, thank you. I'd like to say that before the fire of 2018, the beach house was brilliant. It was a lovely place to go, and acceptable levels in terms of patrons and noise levels and pressure on the local environment. Since the fire, the business has outgrown its original boundaries, and as a result is no longer quite so in harmony with the surrounding area. The main issues being, as other people have said, a slight overwhelming number of people that the local infrastructure struggle to support, increased noise levels and a substantial rise in delivery lorries. My family has had a hut at Mudderford since 1959, and I've been fortunate to spend every summer throughout my life down there, or most of each summer. Additionally, I managed the cafe for 3 years in the late 70s, giving me a good understanding of how things operate in this unique and sensitive environment. If it continues as is, I fear that the delicate nature of this really rather beautiful place will be irreversibly changed. In challenging this licence, our intention is not to harm Mr. Slater's business in any way. Instead, we hope to see the beach house return to its previous state, as it was before the 2018 fire, when the aforementioned problems were not so prevalent and the beach was enjoyed by everybody. Thank you.
Thank you, Mr. Webb. The next speaker, Mr. Stephen Barrett.
Chair, members of the committee. Chair, members of the committee and ladies and gentlemen. My name is Steve Barrett. My family has had a beach hut on the Sandbank since 1988, and I've been chairman of the association, Beach Hut Association, for 9 of those years. I witnessed the gradual development of the cafe up until the fire, and it delivered a mix of service options that was well received by hut owners and visitors alike. It was the centre of the community, providing a shop for residents, a restaurant, a cafe to relax in whilst enjoying the views of the harbour. Since the fire, everything has changed, as been pointed out by our other speakers, and we have now a situation where noise levels are excessive, as been pointed out. My hut is over 150 yards away from the beach house, and during the events I can hear the music clearly from that hut. Sometimes it would overwhelm the music coming from someone's radio 2 huts down. So it is not just a light music being emitted from the site. The other thing is that we witness people with trays of alcohol, open alcohol, wandering along the beach, and then the following morning we're out there going backwards and forwards to the toilets, picking up the empty containers, and then witnessing when we get to the toilets are also littered with those containers. This, as and other members have mentioned about urination down the sides of the hut, I've witnessed it. I've seen ladies down the back of block 3 in the process of urinating. So it's not just an occasional thing. It has happened quite frequently when the toilets have been busy. I would like to see it return to what it was before, a family-friendly venue which attracts families that can enjoy themselves in the sunshine and enjoy alcohol responsibly, and that is my aim really with this particular move on behalf of the association. That's all I have to say. I just would like it returned to that state as it was before the fire. Thank you very much.
Thank you, Mr. Barrett. Could I next call on Dr. Goddard, please?
Good afternoon, Mr. Chairman and members of the committee. The following personal observations relate to some of the issues which are obviously mentioned in the 2015 lease in terms of nuisance, annoyance, disturbance and inconvenience. Our family had a beach hut on Mudderford Sandbank for 44 years. Unfortunately, over the last few years, there has been a pronounced decrease in our enjoyment of the sandbank by the marked increase in footfall caused largely, I feel, by the change of commercial model of the original cafe and shop contained within a building, morphing itself into a confederation of standalone bar and various takeaway enterprises, with at times a burger van, an ice cream van, etc., added and parked on public spaces. Due to the lack of doors or a roof covering a large part of the present beach house, there are problems created by noise from the premises. The so-called background music during the day is enough of a distraction for surrounding huts. However, this relative disturbance pales into insignificance during afternoon, evening and nighttime events from live music and DJs. The sound can be heard across vast swathes of the central part of the beach, making sleeping for children an impossibility. Requests from the management to reduce the volume of the music fall on deaf ears, and lame excuses such as it's their equipment and we can't do anything about it is not acceptable. After these events, disturbances continues as inebriated revellers head towards the road to the head or gunning their outboard engines to impress their friends. Behavioural issues. As visitor numbers have got larger, there has been more pressure on the toilet blocks closest to the beach house. Queues build up, loos get blocked, and council staff are obliged to close these toilet blocks. Waste bins become overwhelmed, and single-use plastic and cardboard detritus litter the foreshore around the beach hut. As the hours progress, the predictable effects of alcohol come into play. The revellers become more boisterous and rowdy, and levels of disturbance increases for neighbours. During busy weekend evenings, male revellers seem to unable or unwilling to make it to the toilet block and take matters into their own hands, to speak, in public spaces between the huts, an unwelcome sight for my grandchildren's eyes. Heavy advertising, by the way, touting is not allowed in the lease, has attracted large numbers to events in the present iteration of the beach house, which has meant the saturation of the building containment area with customers spilling out over the seashore and Hall Road, as evidenced by the photos which you have seen today. As far as increased movement of traffic, the vast increase in traffic from early morning to late at night along the road and harbour foreshore due to the new business model has increased the likelihood of vehicle pedestrian confrontations and also the significant disturbance to hut owners facing the harbour. An inevitable consequence is that designated areas on the beach house footprint for parking is usually full with staff cars, which means the regular delivery vehicles cause pedestrian disruption and spill out and choke the foreshore and Hall Road, as evidenced by the 6 vehicles shown in the photos on a single day. Incidentally, the lease tried and has patently failed to curtail the movements by stipulating the maximum total number of all traffic movements for the whole year. For this 2025, it was set at a modest 1,268 movements, and these movements should have been recorded by the tenants. So, events with too many individuals drinking in a public space surely has been brought about by, and I quote, activities that have a detrimental effect on the quality of life in the locality. By the way, this quote is lifted from the current legally enforceable public space protection orders. Thank you, Mr. Chairman.
Thank you, Dr. Goddard. Next on my list is Mr. Paul Owen.
Leaving the microphone so you've got a better picture.
Thank you, Chair. I've had a hut for over 40 years. I'm about 20 metres away from the cafe. I spend time down there most weeks throughout the season. I'm lucky to be retired, and my children and grandchildren spend a lot of time down there during the summer holidays and Easter holidays. The beach huts are a residential area where we live back to back, just meters apart. There's a sense of community and respect for one another. We don't play our music or our radio loud because quite simply it wouldn't work if everyone did. There would be a complete mash of sound. And in any case, why would you impose your music on your neighbours? The cafe claims to be part of the community. So why does it feel it has a right to drown out the occupants of 30 or so huts who are directly affected by it? I've read over 500 comments in support of the cafe. The most common comment is about it being a family place, good for children, while others mention the beauty and the peace of the place. We welcome those people. But in those 500 comments that I've read, not one single person said they want a live DJ, want live music, or the Ibiza vibes which the cafe promises in its media pages. There's mostly, and I emphasise mostly, no problem with the ambient music that the cafe plays. And I believe that most customers are happy with that. I doubt whether many of those customers think that they should make as much noise as they like and that the surrounding people in their huts should just lump it. Thank you.
Thank you, Mr. Owen. Miss Sally Harris, please.
Good afternoon, Chairman. Good afternoon, everybody else. My name is Sally Harris. I've been on this beach for probably the best part of 50 years. I'm married to somebody who virtually grew up on it. I'm speaking today as someone whose family deeply cares about Hengstbury Head, Muddyford Sandbank, and the unique, fragile environment that makes this place so special. Many of us remember the beach house as it once was, a calm, welcoming, sit-down restaurant where families could enjoy great food. We had a banter with all of you lot. It was great. We had a glass of wine and the simple beauty of the coastline was enjoyed. I reiterate again the mission statement of the beach house. Leave only footprints, the only sound is that of the waves breaking, and create only good times. That spirit of simplicity, respect and harmony with nature defined the sandbank for years. But sadly, in recent times, we have seen a dramatic change. Where once we had tranquility, we now face more littering and overflowing bins, overcrowding and festival style gatherings, it's all been said before, antisocial behaviour and excessive noise, increased vehicle movement servicing the beach house along the narrow access track, blocked toilets and mounting costs to the council. And perhaps most concerning of all, real environmental strain on the site of nature's conservation interest. Adjoining an SSSI and within the green belt, adjoining Hengstbury Head Nature Reserve. This is not Magaluf, it's not Ibiza, and it's not central Bournemouth. This is Muddyford Sandbank, a place of peace, family life and natural beauty. Unfortunately, the shift from the managed restaurant model to a takeaway pub-style operation has brought with it the very pressures that threaten the character and ecology of this place. The cafe itself directly caused litter and crowding we see in the photos available to you today, which you will see later. The sheer scale of unmanaged visitor activity has overwhelmed both facilities and infrastructure. And I just need to say I'm on the committee and I am the beach officer down there, and I liaise a lot with the council, with the management of the beach all the time. So I know exactly what happens in those toilets when there's lots of people there. My computer is full of pictures. The old infrastructure cannot cope with the resident beach huts, alone, and is very costly for BCP to keep them fit for purpose. Let's not forget, all sewerage from the sandbank is pumped through a single pipe system via multiple pumping stations. Rubbish removal relies on one narrow access route shared by vehicles and pedestrians coming through Hengistbury Head. These facilities are used not only by visitors, but also serve as the everyday amenities for the beach hut owners. The truth is, this site simply cannot sustain the volume of activity that a festival-style cafe encourages. Once fragile environments are damaged, they rarely recover. It's teetering now on this cliff edge. We aren't calling for closure. Far from it. We are calling for balance. We are asking for a return to the restaurant model that worked so well before. We're asking for alcohol served only with a substantial meal, book tables to manage numbers, a small takeaway offer as an ancillary service, operating hours in line with planning conditions, and a focus on quality, not quantity. This approach will protect the sandbank, ease the burden on the council's coffers, and allow everyone, visitors and residents alike, to continue enjoying this extraordinary place responsibly for generations to come. We, you, have a duty to look beyond short-term gain and think holistically, to protect quality of life, natural beauty and community well-being. Once lost, the special character of this area cannot be brought back. Let's honour the spirit of the Beach House mission, leave only footprints, hear only waves and create only good times. This is now in your hands. If the current pub-style model is allowed to perpetuate, it will be on your watch that this special place is destroyed forever. This is the Muddyford Sandbank we want, and we want it to perpetuate, but we want it to perpetuate in a managed, sensible way. Thank you very much.
Thank you, Miss Harris. Mrs. Elizabeth Pritchard.
So, good afternoon. My name is Elizabeth Pritchard, and I'm a long-term member of the Mudderford Beach community. 5 generations of my extended family have enjoyed this wonderful amenity since 1949. I've grown up there. I was there as a baby. And it's my hope that future generations will continue to do so. In April this year, I and many other beach residents accepted an invitation from Mr. Richard Slater to attend a meeting at the Boathouse, where he explained his concept for the rebuild of the Beach Cafe, which has been recently approved by the BCP Planning Committee. He assured us that the intention was to revert to a principally sit-down restaurant contained within the footprint agreed. Like many others, I was greatly relieved to hear Mr. Slater's intentions. However, for me, it's how the building is operated that is of the highest importance. The period since the fire has been long and difficult for all. It's included the COVID period, which has brought its own problems, and there has also been the well-understood financial issues over the rebuild. During this period, the way that the cafe has been operated has changed, and in my experience, negatively. Due to the restrictions of COVID and the nature of the temporary building, certain practices have been adopted that have had the following impact on my family. The operation has spilled from the confines of the building to the surrounding outside space. There is often a constant hum in the background from canned music played in the cafe. When live music is played, that constant hum becomes something much louder and more intrusive. Our hut is immediately next to Block 3 toilets, those nearest the cafe. The pressure during the summer season is considerable, The toilets are often blocked and out of action. During the widely advertised events at the Beach Cafe, the pressure on the facilities is extreme. The toilets become very unpleasant. In addition, often the remnants of takeaway food, and more concerning for the well-being of my grandchildren, the remains of alcoholic drinks in takeaway glasses are left in those toilets. The expansion of the takeaway side of the business has led to considerably more waste being generated, litter created, which results in unsightly bins and additional noisy bin collections, often at unsociable hours. Is it not reasonable to ask that the takeaway element of the business is now reduced to pre-COVID levels? The nature of the widely advertised events, which have been a feature of recent years, have been difficult to comprehend. The advertising does not seem to suggest that people should come to the beach to enjoy its benefits, but rather for live music, by its very nature usually loud, and alcohol, often spirits. We've seen customers who are apparently unable to walk in a straight line leave the beach driving motor-powered watercraft. How long before a serious accident occurs? I cannot believe that a beautiful, family-orientated beach with so many natural features to enjoy is an appropriate location for these events. The increased commercialisation of the Beach Cafe has led to a large number of delivery vans at all times of the day. We effectively have to cross a road to get from our beach hut to the harbour. Beach hut residents and day trippers alike need to be constantly aware of traffic, an unexpected hazard on a sandy beach, particularly for children. The emphasis on increased revenue and footfall appears to me to be at the expense of both the environment and other beach users. The Beach Hut Association has tried very hard to work with the current tenant to find a workable solution for the rebuild. It is my belief that with the huge backing of its members, the Beach Hut Association is now appealing to the Licensing Committee to set in place ground rules for an operating model which supports a harmonious relationship between the tenant and Beach Hut residents and allows Motherford Sandbank to be enjoyed by us all. Thank you for your time and attention today.
Thank you, Mrs. Pritchard. Councillor Judy Richardson, please.
Good afternoon. I'm speaking on behalf of a Motherford resident. For nearly 50 years, our family has been part of the community of Motherford Sandbank. 4 generations have cherished this place, not just as a getaway, but as a sanctuary where we have shared countless memories, watched our children play freely, and found peace in the unique beauty of this natural environment. Motherford Sandbank is more than just sand and sea. It is a delicate ecosystem and a community treasure that deserves our respect and care. Since 2018, this once family-friendly enclosed cafe and restaurant, of great benefit to the Sandbank, has become a social media attraction for loud live music, themed events, and takeaway alcohol consumption. Customers spill out over the surrounding area, often displaying unacceptable levels of alcohol-driven behaviour. Consequently, waste management is now out of control, with plastic and litter disposed of across the Sandbank and council bins overflowing on a daily basis. Toilet facilities are completely insufficient for the number of people now requiring their use, creating mechanical failure and queues which have resulted in regular public urination. Prior to 2018, one delivery has been replaced by the constant disturbance of several deliveries per day to meet the increased food and alcohol demand. Most concerning of all is the effect upon our children, who can no longer enjoy the simple, peaceful childhood environment that this beach once offered. Instead, they are exposed to behaviours that set poor examples driven by excessive drinking and noise. For the sake of the Sandbank's future, for families, for children, and for the environment, I respectfully ask this committee to restore the cafe to its original format.
table service for food and alcohol with no takeaway alcohol. I also urge strict control of music volume in this open air space. These measures would alleviate the negative issues described and return life on the sandbank to the beautiful experience we remember and loved. In closing, whilst I appreciate the importance of local business thriving, it is disheartening that current priorities seem focused more on maximising footfall and revenue than preserving the tranquility and community spirit that make Mudderford Sandbank so special. Thank you.
Thank you, Councillor. Now, I also understand that there are a series of videos which will accompany the representations, and unfortunately we need to go into an exempt session. Therefore, I'm asking the committee to consider the following resolution for part of this hearing, that under section 14.2 of the Licensing Act 2003 hearings, Regulations 2005, and with regard to section 100A(4) of the Local Government Act 1972, the public be excluded from the meeting for the following item of business on the grounds that the public interest in withholding the information outweighs such interest in disclosing the information, and that it involves the likely disclosure of exempt information as defined in paragraphs 1 and 2 in part 1 of Schedule 12A of the Act. Are members happy?
Yes, sir. Agreed, Chair.
Thank you. welcome back, ladies and gentlemen. Before we move on, questions. Members, do you have any questions at all?
Yeah, just a quickie one for the officer. Has there been any temporary event notices issued for the premises?
Not that I have it on my record when I did the checks, so I couldn't see anything that was on there. But maybe it can be clarified and I can look into it, but from my record, no.
Okay, thank you.
Councillor Farquhar?
Yeah, so as mentioned in some of the presentations about antisocial behaviour, and there was also mention of the Public Spaces Protection Order, which covers the majority of Bournemouth, Christchurch and Poole, whereby people that are acting in antisocial behaviour can be intercepted if there's alcohol involved. Have there been any call-outs for the police or any reports to the antisocial behaviour team, any of the seafront rangers or any other officers such as the community enforcement officers to that particular location?
None that are recorded on my system that I've checked. And the Dorset Police have not made any reps either.
Thank you, Tanya. Any questions at all? Okay, right. In which case, I'd like to now move on to Gerald Gourier, who's representing the premises.
I am.
Thank you, Gerald.
There's a great deal for me to deal with, but I sometimes think, in fact, I often think, it's useful for a licensing subcommittee to know where a lawyer's submissions are heading before he embarks on them. Mine are heading towards a focus on the prevention of public nuisance and the potential, the obvious potential of these premises to create public nuisance. And I put it in terms of potential because there is a dispute between the parties as to whether the premises have crossed the threshold of public nuisance or are simply providing music that can be heard. That dispute doesn't have to be settled because it is my submission to you now and was my clear advice to the client that where you have premises licensed for the sale of alcohol that take up the entitlement given by the Live Music Act to provide live or recorded music until 11 o'clock at night, particularly if those premises have no roof, then there is an obvious risk that the provision of music may cause a nuisance to those in the immediate vicinity. And the licensing objective is the prevention of public nuisance, and you have ample authority if you think it appropriate to impose conditions that would prevent that public nuisance. And it's pretty obvious, I hope, that I'm heading towards a noise management plan. I'm also going to be making submissions about the supply of drinks in open containers, and I will make submissions about littering, bottle disposal, etc., and suggesting appropriate conditions. But before I embark on all of that, can I just deal with some basic legal matters? The central question, it has been said, but it needs to be said publicly, just in case it hasn't fully dropped home with the public. The central question that you have to determine this afternoon is what steps do you think it's appropriate to take to promote the licensing objectives? Anything that falls outside the promotion of the licensing objectives, however commendable or attractive that is, falls outside your statutory function this afternoon. And I'm just going to give a few examples, although the material we have heard is full of them, but I'll give a few examples. Modernizing the license, for example, is an academic pursuit. It has little or nothing to do with the promotion of the licensing objectives. But more importantly still than that, not one of the representations made asked you to modernize the license. It should be put entirely to one side as not germane to what you have to decide. A change in the operating style is very dear to the hearts of those, and it's understood. I'm not dismissing it as nonsensical. It's understood that many wish there hadn't been a change in the operating style. But provided an operator does not undermine the licensing objectives, and provided he operates within the terms of his license, he is entitled to operate any style he wishes. I will appreciate many don't like it, and you will have read the petition, many do like it. But it, in and of itself, is not something that triggers the licensing objectives that an operator has changed the style of his operation. It's what he does that matters. The aspirations of the Mudderford Sandbank Management Plan, I'm not going to turn to it. You heard Mr. Grant read out a section in quite some detail. In short, the plan in that part of it that was read to you seeks to restrict knowledge of the sandbank. And indeed, there is a steer to anybody who might read what the council publishes, a steer of them away from the sandbank. One quite sees why that is done, but it has nothing whatever to do with promotion of the licensing objectives. It is quintessentially a planning matter. And then the last of the examples I'm raising refers to the supper hour certificate. With respect, Mr. Grant, he has got that completely wrong in law. You were referred to, and I'm going to ask you to take a quick look at, please. It's page 40 of the public reports pack, and condition just over halfway down the page, condition 120. While that's being pulled up on computers, under the 1964 Act, any premises licensed for the sale of alcohol could apply to the licensing justices for a certificate that the premises were structurally adapted and habitually used for the purpose of, I'm going to summarize, providing people substantial table meals. A public house could apply if it was structurally adapted. That means it had a kitchen, and in terms of structure, there was space for people to sit and eat. Public house could apply and was granted. I think I spent the first 20 years of my professional life asking for supper hour certificates. Wine bars could apply. And the certificate that we can see the terms of it at paragraph 120 is just that. It is a certificate, not a restriction. It certifies that premises are structurally adapted and bona fide used for the purpose of habitually providing people with table meals. In possession of a certificate, the licensee could set aside a part of the premises that is dedicated to people taking meals. If he did that, he was entitled to an extra hour on his permitted hours. Permitted hours have gone now, as you know, there's 24-hour licensing if you wish it. But he was entitled under the old law to an extra hour. In the evenings, that was usually 11 o'clock to 12 o'clock, or if the permitted hours were 10:30 to 11:30. He was not required to set aside part of the premises. In possession of the certificate, he could decide whether to do so or not. And Section 69 of the Act makes it perfectly clear he could decide to do so and then change his mind. Then he would lose the extra hour. Not for one moment does the attachment of that certificate under the conversion of the license mean that all of a sudden it's turned into a requirement only to serve liquor with table meals. It simply does not. And I will be asking those sitting either side of me to talk to you briefly to negate the proposition that these premises always used to operate as a restaurant. They didn't. From time immemorial, you will hear, they have sold, and they were entitled to sell, alcohol to people who might take it and sit at one of those tables and drink. A group of them could. They were perfectly entitled to do so. There am I getting slightly hot under the collar, but it's a matter of law, in my respectful submission, that's black and white. There is no restriction whatsoever under this license that people have to take a table meal before they can be given alcohol. That's all I want to say in terms of what may not be taken into account when you're considering what promotes the licensing objectives. On the licensing objectives, it's my submission that the only one that is realistically triggered is the prevention of public nuisance. The others aren't. I've dealt with this to some extent in my written submissions, and so I won't trawl over that again. But I quoted from the guidance in my written submissions, and I found a better quote from the statutory guidance in paragraph 2.1, which I'll simply read. It's only 3 short lines. Licensing authorities should look to the police as the main source of evidence on crime and disorder. And it won't do, it's a nice try, but with respect, it won't do to say, well, these premises are remote, so you can't expect the police to be helping you. We've heard evidence in the representations against me that the police have been called, not to us, I hasten to say, but police have been called out to various things. We heard just this afternoon of somebody trying to break into one of the huts, and the police were involved in that. We heard or read in the representations that occasionally a police car can be seen patrolling. Police will have on record all calls to them and all reports of crime. And their response to this application is they have no representation to make. In my submission, that means, as night follows day, that the prevention of crime and disorder licensing objective isn't realistically triggered in this case. Public safety, the guidance of paragraph 2.8 is that it is the safety of those using the premises that is under consideration. I don't think there's any evidence before you at all, or any representation at all, to the effect that those using the premises are endangered in terms of safety. And then finally, the protection of children from harm. The guidance says the harm means moral as well as physical, but the suggestion that children are morally harmed by exposure to anything that you've seen in the photographs or will see in the videos is, I would say, completely untenable. So we're driven to simply looking at the prevention of public nuisance. Now, the public nuisance complained of falls under 6 headings. Noise nuisance, principally, but not exclusively, music noise. Nuisance, in terms of obstruction caused by customers spilling out with drinks. Thirdly, behavior of customers, or I should say alleged customers, because evidence is thin on the ground that what you have seen people doing untoward, urinating between cabins and all the rest of it, the evidence is thin on the ground in terms of a connection between those people and customers of the beach house. But that's one of the headings. Behavior of customers beyond the immediate vicinity of the premises, and those are the important words. 4, 5, and 6 I'll take very quickly. There's littering. You heard there are vast quantities of plastic and rubbish to be seen again. I'm going to ask you to have in mind the photographs and the videos you're going to see to determine the strength of that concern. The hours of bottle disposal, and 6th, the hours of deliveries. Noise nuisance is, the first 2 of those are the most important. I'll take noise nuisance first. There is, of course there is, audible music in beach huts. Whether that's a public nuisance is the question of dispute, but it's not a dispute you're required to resolve. You would be hard put to do so if you had to resolve it, because of the distinct lack of what we usually have before a committee, I was going to say before us, in terms of the public nuisance objective being made out. Complaints to the environmental health officer are negligible over 5 years. There is no independent verification of what we have heard in the representations. And for example, there is no noise diary, which one so often sees completed by residents who say we've suffered noise nuisance for so many months or years now. And a noise diary is pertinent, and I'm going to ask you please to look in the public reports pack at page 71. And what you're turning up there is from Environmental Health Department to Claire Bath,
on the 20th of June this year, and she had made a noise complaint, and she is thanked for reporting it. And what the environmental health officer says is we need to monitor the noise complained of from within your home or premises, and therefore asking you to complete a noise diary for 2 weeks before we investigate, unless the noise is continuous, like an alarm. And it was possible to download the noise diary from the council's website. If you go to the previous page, you'll see that no noise diary was completed. Claire Bath said she was unable to fill in a 2-week diary because she was not there all the time. I make no complaint about that, but the suggestion that you haven't heard from the Environmental Health Department because they've got too much on their hands is just not fair or correct. There was the Environmental Health Officer prepared to come and investigate if only she was given the relevant platform to do so. It wasn't that she was too busy to do so, as has been suggested. Now, I want to emphasize, I hope I've made it clear, but I want to emphasize, in case I haven't made it clear, that I am not saying that because there is insufficient material before you to reach a conclusion as to there being a public nuisance, I'm not saying, well, therefore that's sorted out. I don't say that. I say that you have ample material to take steps, if you wish to do so and think they're appropriate, to prevent there being public nuisance. I am inviting this committee to require, as a condition on the license, a noise management plan that is agreed by the Environmental Health Officer or the relevant officers and approved by the licensing authority. I suggest it would be disproportionate to require the premises to close altogether the moment you make your decision, as has been requested, until they have a noise management plan. You've seen my written submissions that ask you to have a realistic and pragmatic view of the fact we're approaching the winter. We're approaching a period, in fact, we're in a period where use of the huts is much less than it has been. If the premises were required to close until a noise management plan was agreed, the joggers and the dog walkers that are using it, I was down there yesterday to have a look for myself, they are around. The staff would have to be laid off. It would be a disproportionate response to the problem. What I'm asking you to do is say, realistically, from now onwards, for a few months or so, nobody is going to be affected if there is no noise management plan until 5 o'clock. From 5 o'clock onwards, from sunset in many ways, but we've said 5 o'clock onwards, a noise management plan must be in place, or I'm putting it the wrong way around. From 5 o'clock onwards, the premises must close unless there is a noise management plan in place. The applicant's proposals for the content of that noise management plan are not agreed, and I want, if I may, to ask you to turn up to the latest of the supplementary bundles that contains my written submissions. From page 12 onwards, I deal with what has been suggested to you as the content of the noise management plan. And if you, I'm going to wait until you have that because I'm going to just go through each one of these proposals. My essential stance is it's premature to set in stone now what should be in the noise management plan before it has even been discussed with the Environmental Health Department. So that's my essential submission. It really is too early to start talking about the nuts and bolts of it. But I wouldn't want you to think that I'm ducking, or my clients are ducking out of what will inevitably have to be in that plan. And if we look at 12A, that is that a noise limiter must be fitted to the musical amplification system and maintained, etc., in accordance with the following criteria. The limiter shall be set at a level determined by and to the satisfaction of an authorized environmental health officer. And these are the important words for my submissions. So as to ensure that no noise nuisances caused to local residents. So what we're looking at there, and I agree with it, I'm just saying for the reasons I've given, it shouldn't be set in stone today, but I agree with it in principle. A noise limiter should be fitted, which will ensure that no noise nuisance is caused to local residents or businesses. Just park those words because I'm going to return to them. B, again, is agreed in principle. B, C, and D really amount to nobody shall tamper with it, they shan't be allowed to tamper with it, and they shan't replace it. E is very important. No additional sound generating equipment shall be used on the premises without being routed through the sound limiter device. So we have a proposal which is agreed in principle that all amplified music should be sent through a noise limiter, and that noise limiter should be set so as to ensure no nuisance is caused to local residents. Which brings me to F, which suggests that music must only be played at low-level background level and only within the cafe area to minimize noise breakout to the surrounding beach house. That is completely unnecessary if we have a noise limiter that ensures no nuisance is caused to local residents. It also predetermines what the noise management plan shall be. Completely unnecessary. The solution to the whole problem of noise is a noise limiter that ensures no noise nuisance. H, duration of music entertainment should be no longer than 3 hours. That's a planning condition. It's likely that that will be part of the noise management plan. It's not disputed in principle. I is, amplified music is only permitted between 10 in the morning and 9 o'clock in the evening. I just say, why? If it's not causing a nuisance, if we already have an insurance that no noise nuisance is caused to local residents or businesses, no good reason has been put forward yet why that music should not be allowed until 11 o'clock, which is entitlement under the Live Music Act. If it's not causing a nuisance, why prohibit it? And then the rest of them, I think, are agreed in principle. You will have seen as an annex to my written submissions a host of responses to other conditions that are proposed by the applicant. I'm not going to trawl through them now because I would simply be repeating what I said on paper, but I do ask you please to read my responses to their proposed conditions because by no means are they all accepted. Some are and some are not. We've asked for permission to have deliveries between 8 and 12? Yeah. Because the delivery service operates in a 4-hour window. Limiting us to 3 hours would effectively prevent us being able to book deliveries from those people. 12 o'clock midday is not an unreasonable time to have the curtain falling on deliveries. That is all I have to say about public nuisance. The second of these 6 that I'm going to deal with concerns customers spilling out of the premises. What has been highlighted is the operation of these premises since the fire, and to some extent overlooked has been COVID, because during the COVID pandemic and the lockdown, restrictions on unlicensed premises were significantly relaxed, so as not just to permit, but to encourage outdoor provision of alcohol for people. And the purpose was, first of all, to ensure social distancing was maintained, and secondly, to make sure businesses didn't go under, because premises where the alcohol could only be sold, supplied, and consumed inside could not operate during the lockdown. Social distancing was impossible, and so the government decided to relieve the restriction on people on licensees to have liquor only served to customers inside the premises. And
not just the beach house, but throughout the country, pubs, licensed premises, beach places, town places, took advantage of that relaxation. The relaxation came to an end on the 31st of March this year. It was for a period that was extended, so it came to an end. So from the 31st of March this year, the licensee of the beach house is required to operate according to the terms of its current license. Now I'm going to ask you to take a look, please, at page 40 of the same bundle. Which here it is. At the top of the page, condition 1.17. This is the current condition on the premises license, and it reads, the taking of alcohol off the premises shall take place by the end of the first 20 minutes after the permitted hours. That's irrelevant now because permitted hours don't exist, but this isn't irrelevant, it is incredibly important. And shall be supplied or taken in a sealed container. And that means, quite simply, that from the 31st of March this year, the premises should have been operating and in accordance with that condition, and not throughout this summer, they shouldn't have been serving to people in open containers for consumption of the premises. That should not have been happening. It did. I'm instructed that those either side of me did not appreciate that the matter had come to an end. I hope there is some sympathy that you have for both operators and customers who had been enjoying for nearly 5 years what was offered by the beach house outside, and that it would take perhaps a difficult adjustment of them, customers and operators alike, to return to what should be under the license. But I've given the firmest of advice to my clients that from now onwards, they must comply with condition 1.17, and they shall not, unless that condition is varied, they shall not allow customers to leave the premises with holding alcoholic liquor, whether it's beer or wine or whatever. I think it was in Kim Stanley's statement, it was suggested that in order to bring this about, there would need to be significant retraining of staff just to get it into their heads. You've been enjoying this over the last 5 years, but you cannot let it happen now. And also, notices in abundance should be placed at the exit or exits to these premises, letting customers know that what they've been able to do over the last 5 years, they cannot do again. It's my submission that adherence to condition 117 goes a substantial way to answering what the residents' concern about people walking up and down the beach holding open containers of liquor. If anybody says, well, if they're allowed to operate as an off license, which they are, if they're allowed to do that, well, people will simply open the cans or bottles when they get outside and we'll have the same problem all over again. One can quickly test that that is wrong because we've heard high praise for these premises and the operation of them up until the fire. Well, during that period, they had precisely the same off-license entitlement. Up until the fire, they were entitled to sell to people in bottles and cans, and no one has complained that before the fire they had this problem. There is no good reason, there's speculation, but no good reason to say that restricting themselves in accordance with my advice and in accordance with the license condition will not be a substantial answer to the problems that are complained about. And it's quite something, I suggest, for the licensees to give me permission to point out condition 117, because with respect, Mr. Grant it has been no part of his submissions to you. Indeed, he was recommending that that condition be deleted along with all others either side of it. A very bad idea in my submission. Of course it shouldn't be deleted. It's an integral part of the solution to the problems that the residents are facing. Thirdly, the behaviour of customers beyond the immediate vicinity. Government guidance at paragraph 1.16. I'm going to read it. Licence conditions cannot seek to manage the behaviour of customers once they are beyond the direct management of the licence holder and their staff. But they may impact on the behaviour of customers in the immediate vicinity of the premises or as they enter and leave. And this is where I said a moment ago I was going to refer to the photos and videos, particularly the videos. I'm going to ask you when you see them to find it very difficult, if not impossible, to conclude that you are being shown anything other than a diverse crowd of adults and children behaving as you would expect them to behave. There is no hint of disorder or crime. Nothing at all to justify the draconian conditions that the association is asking you to impose. 4, 5, and 6, I said I would take quickly, and I will. Littering. At page 87 of the public reports pack, 88 and 89, we have, I think, the only evidence of littering. We can see in the top photograph on 87, there's certainly a couple, or one or two plastic bottles. There's something, the black, by the way, is shadow, it's not litter. There's something under the bench on the second of the photographs. The photographs on page 88, top one shows 2 plastic bottles. There's something on the lower photograph, and I can't make out anything on the top photograph, page 89, but there must be something, otherwise the photograph wouldn't be taken. Yes, there's some white, which may be litter, and there's a bit on the lower photograph. You were told that there was a vast amount of litter and plastic scattered all over the beach. If that really is not an exaggeration, a terrible exaggeration of the position, one really is entitled to say, where on earth, why didn't anyone take a photograph of it? You will hear from both Rich and Kim Slater that in the morning before the premises open, their staff do pick up litter, which they find there's inevitably some litter everywhere, and they do their best to pick it up. But litter disposal, or the evidence of litter in this case, falls a million miles short of anything that could be called a public nuisance. Proposed condition 14, I know I said I was going to ask you to read them, but I'll just touch on it. I'm not going to ask you to turn it up now. It's proposed condition 19, in fact. During the hours of operation, the licence holder should ensure sufficient measures are in place to remove and prevent litter or waste arising or accumulating, etc. No problem with that at all, but we would go further. The cafe is happy to agree to the placing of 2 bins outside its curtilage and conducting regular litter picking for an 80-metre radius, which is in accordance with the new planning condition. Bottle disposal, we agree, should not take place between 9 o'clock at night and 8 o'clock in the morning. So there's agreement there. Deliveries, as I've mentioned, there's a 4-hour window. Otherwise, deliveries are going to be very difficult, if not impossible. We are asking permission to be allowed to accept deliveries between 8 in the morning and 12 noon. Now, I mentioned that there are 2 either side of me who I'm going to ask immediately to give you whatever assistance they can and to offer themselves, as it were, for questioning. I'm not going to attempt to sum up what I've just said in only a few minutes by comparison, but I've been trying to be efficient. I hope my clients aren't bitterly disappointed that I haven't spoken for an hour and a half, but if I summed up now, I would leave myself nothing to say at the end of the case. So I'm going to leave it there. And first of all, I'm going to ask Rich, please, who's sitting here, would it be permissible, because it would be efficient, if I treat him in a sense as a witness and ask him to limit himself to answering briefly a few questions that I ask him?
Can I just first of all, ask the committee if they have any questions for you?
Before we go into that,
Yeah.
by all means, yes.
Members?
What are you guys doing to sort of reduce the number of vehicle movements? We've heard sort of about staff coming and going in cars. Are you car sharing down the path? Are you trying to bring sort of deliveries down in one go rather where possible, that sort of stuff?
When he comes, can I ask Mr. Can I ask Rich, I'm going to call him, to deal with that? What I will say about it is it's, again, quintessentially a planning matter. The number of vehicle movements should be part of the planning permission.
And so how many weekends over the summer when the beach hut people are allowed to be there, to sleep there, how many of those sort of days or weekends or weeks or whatever how you want to quantify it, are sort of events happening where music is played above sort of ambient levels?
Again, I'm ducking the question, but it will be answered. And again, I'll have the same coda to it from me, that this isn't a planning issue. It's a tricky one to get right, but it's a planning matter. The number of events, shall we call them for the moment, per week or per season is a question for planning. How those events are conducted is a question for licensing, and they must be conducted in a manner that does not undermine the licensing objectives. But we have an answer as to how many are proposed. Yes, we do.
Councillor Farquhar?
Thank you, Chair. Through you. Yes, from some questions to ask of the actual operators and their premises license holders, but I'll hold those until they've done their submission. It was interesting that you bring up the COVID practices and the extension, etc. And I think it's wise and salutary that you've reminded them that they've traded for the whole summer in breach of what's expected of them as a responsible premises license holder, DPS, and upholding and promoting the licensing promises. I just wanted to expand a little bit on the prevention, and you talked about how do we tell which customers are coming and going and whether their behaviours are related to the fact that we're now, to my understanding, you're going to move to off sales that are in closed containers. Yes. So these would be cans, these would be bottles with the lids on, etc. And you also touched upon there's nothing to prevent somebody else opening that bottle. What measures will you take to ensure that if they open those bottles off premises, off the actual curtilage itself, and I have a question on that, are return customers throughout the day for off-license sales?
Yes, well, the measures we take, it's very difficult. The government guidance doesn't expect measures, much by way of measures to be taken to deal with the behaviour of customers beyond the immediate vicinity. But that having been said, one can encourage them in all manner of ways. As you probably know, the benches in front of the beach house are a subject of controversy. There are people that say we're not entitled to use them, people that say that visitors aren't entitled to sit at them. That's odd, but that's what is said. If I'm right, and there's nothing I say boldly to suggest I'm not, that the operation of these premises until the fire is praised as not causing problems. There was a dramatic language, I can't recall it right now, but they simply didn't cause a problem. That was
at a time when off sales were permitted. So whatever is feared that people will do, they didn't do before the fire, even though they had the entitlement to do it.
If I may, Chair, just as a follow-on to that one, is that I asked specifically what measures they would take in the current situation,
Yes.
not the situation pre-fire and pre-COVID. You touched yourself, Chair, through you, on the fact that behaviours have changed. It will take an education for the patrons of this particular premises. I think you used an abundance of notices and staff training. But my question specifically is, what measures are you going to take? And let's talk about the curtilage, because obviously we've identified that the practices which have been going on hasn't been strictly within the licensing premises. So what is the curtilage for on premises, e.g. somebody buys buys a drink at the bar and says, well, fine, I'm going to sit down on this bench or that bench. So can we just clarify whether these benches, where you say there's some controversy, is actually within the licensable area or is outside of it?
Outside. If you think it's appropriate that customers who've purchased alcohol via an off-license sale, if you think it's appropriate that they should be discouraged or even prevented from sitting on the benches until all this is finalised under the licence for the rebuild, which is ahead. But if you think it's appropriate that until then, they should be discouraged from sitting there and drinking what they've just purchased, pulling off the top of the can and drinking it, then just as there are going to be patrols of people to pick up litter and to do what they can to prevent that accumulating, that there could be a condition that we patrol, our staff regularly patrol the outside area in the vicinity of the premises to ensure that no nuisance is being caused by people who've purchased alcohol by an off sale. I put it that broadly because if no nuisance is being caused, one says, well, why on earth should they be stopped? So the word's been used quite a lot. The world of the beach house, when it is not going to be selling liquor in open containers, is so different from what has taken place over the last 5 years. My optimistic anticipation is it is going to be gratefully received by the beach hut owners as a substantial improvement and answer to their fears.
If I may, Chair, I do think there's a potential for a condition being added there. I'm not going to propose one just yet because I don't think it's fair to any party to do it on the hoof. But I'm just raising the perspective of the fact that we are addressing a review application for the current license, not any future license. No. I'm not interested in fixing that future license. And that's laid out as regards what has to happen for a premises which may or may not be built after December 31st of this year. That's that new license. And that's for yourselves to work with all the appropriate authorities rather than review of this current license. So if there's a condition being offered, then I think it should be very carefully considered in the nature of the environment which we're in today, having gone through, like you say, 5 years of post-COVID and so on and so forth, and behaviours of patrons. So I think it's beholden that we must be aware of that, particularly if there is behaviours that are outside of the immediate curtilage, whereby the patrons have purchased from what I would suggest is probably the only off-licensed premises within about a mile's walk. So I think there is a degree of consideration there for any condition which is placed. I have one last question. You referred to photos which have been in the submissions. I recall seeing photos which were of commercial bins overflowing.
Yes, I'm going to ask Rich about that. Yes, that's different from the littering of the beach, but that needs to be addressed and it will be addressed, yes.
Excellent. Thank you, Chair. No further questions.
Thank you, Councillor Farquhar. Gary, did you have any questions at this point in time? No. Thank you. Please continue.
Then if I can, continue calling you Rich. We're going to deal with this with a few questions from him. Please answer as briefly as you can, whilst giving a full answer, but keep it short if you can.
The suggestion has been made that the premises have broken promises they've made over the years as to the intentions with regard to the beach house, and that they've dragged their heels since the fire. Can we just rattle off the incidents since the fire? And I'm going to bring this nearer to you. We all know the fire was in 2018. Was it late in 2018?
November.
And the rebuild, obviously, of the premises is the landlord's responsibility, not yours.
Correct.
The council's proposals in 2019 were proposals on which they applied for planning permission, but the objections were so strong all round that the planning consent was withdrawn before it was even considered.
Correct.
The council then we had COVID.
We did.
And the lockdown. When that was over, thankfully, was it May? I vaguely remember May the 29th, 2022.
I think that was the final.
I'm looking for a nod from my opponent. Anyway, whenever it was, COVID happened and we all remember it and experienced it. After it, the council proposed a like-for-like rebuild of the premises.
As part of their responsibility.
Oh yes, it was their responsibility. And that planning was approved in October 2029.
21.
Oh, I misread my own writing. Quite, thank you very much. I don't think we've reached 2029
Not quite.
yet, no. The Beach Hut thought it a better idea to take advantage of the fact that there was to be a rebuild and submitted its own application for something improved on simply a like-for-like.
That's correct.
And did it receive, well, you tell me how that was received by the hut owners.
It was a positive response. We engaged with the hut owners at that point in time, and I think Darren and Claire would both agree that it was received as a better proposition than the like-for-like rebuild was.
The planning approval was given in December of 2022, and then, as we know, the council, looking at the cost of it, I think 1.5 million, and only having 300,000 in the kitty, said, we're terribly sorry, we just can't afford it.
Correct.
And so in those circumstances, you put in your own planning application, which would involve, I think, unless I'm jumping the gun, no, I'm not. You agreed to fund part of the cost. If the cost was a consideration, you said, okay, we'll fund part of the cost. We'll have a cut down version of what had been approved just quite recently, the year before. And you've put in planning permission for a less expensive design. Planning was applied for in May of this year. There were some objections, but there was a consultation with hut owners.
We had a consultation with the hut owners at the boathouse that they were all invited to through the association.
And by and large, happy with it?
We received positive feedback on the day, on the evening itself.
All this took
no objections to follow.
All this took time. It was approved, as we know, the 23rd of October last. How do you respond to the suggestion that you've dragged your heels on this?
We have been pushing hard. I say we, I mean Kim, essentially, has spent a lot of time and money employing our own architects to get designs drawn up, employing our own planning consultants to push these through as fast as possible, engaging with the various groups outside of it, including the Hutty Association, to ensure that it could go through planning as smoothly as possible. We have always, at every step, been pushing council officers, first from Christchurch Council, as it was at the time of the fire, and then through into BCP to find a resolution to get this rebuilt. We're now in a position where we have planning permission for something that we do plan to build. Unfortunately, that came in too late in October for work to happen this winter. The temporary planning does run out, which is why we've applied for an extension so that we can build next year.
Right. Had there not been delays, nothing to do with you, not your fault at all, but had those delays not occurred because of the need to obtain planning and the various objections along the line there have been, was your original hope to start building now?
Yes, I've got a long trail of messages with builders, engineers and various other people. We had been trying to push to build this winter. We had got everything in place, but we didn't have the planning permission in time to do it this year.
So you've applied for an extension of your temporary planning permission that expires on the 31st of December. You've applied for an extension of that. You asked for 2 years as a safety net, but in reality, are we simply looking at you wanting permission to carry on operating throughout the next season with the intention of starting to build about now 2026?
Our plan is to commence work towards the rebuild in January so that we are ready come September 2026 to get on, remove the current temporary setup and start build so that it can then open in time for Easter 2027.
Then I'm going to turn to waste that I promised I would do. It's page 56, of course.
We've got a question from the member.
Yes.
Councillor Farquhar.
Thank you very much. I appreciate the questioning to sort of prompt the relations and sort of smooth over perhaps the situation that we are and look into the future. As we've heard, people have been promised the future for quite a while. So my question is this: I've not had sight of this planning application, but it's a fairly simple one because from what the presentation which you've just done with that question and answer session is that the like for like wasn't acceptable. There was a planning permission that went in. So the question is the proposed rebuild to be hopefully opened in Easter of 27, commencing in 2026, is it a roofed establishment? Is it a roofed premises?
The current plan is no, it isn't roofed, no. The noise management plan would take account of that and ensure that there was no nuisance caused.
If I may ask a follow-up question then, is Chair.
Can I just say I'm fairly certain there is plans on the agenda papers showing what went through the planning a couple of weeks ago.
Yes, I appreciate that, Chair. I just wanted to establish for the viewing public and those who are here is that what's been proposed, apparently agreed by the Beach Hut Association in years gone past, or period of time gone past, is that the plan that's going to allegedly, apparently hope to be commenced in 2026 is in fact an open roofed location.
Yes.
And that was agreed with the Housing Association, sorry, the Beach Hut Association.
On consultation with them, that wasn't a problem, provided there is a noise management plan in place. That's the point.
Thank you for that.
Then I was going to turn to these waste bins, Rich, if you can.
Yep.
You can share mine. It's page 56 of the big supplementary bundle. What is the position? We've looked at the lease, and we see that you can come to terms with the council. What is the current position regarding your consultation with the council and the agreement, the understanding there is between you as to use of these bins?
I'll try to be as brief as I can, but to Gerald's frustration, I do talk a bit more than he likes. The bins that you see in those photos there are the public bins in the bin corral that is outside of the beach house. They are bins that are there to be used by all the general public on the head, as well as the hutties to dispose of their own rubbish into these bins as well. We have our bins on site that we put all of our rubbish into. We have an agreement with the council whereby we will use the same bin collection company. In previous years, this was a private company that the council employed, that we then employed on top of. It was taken over last year by BCP in-house waste collection services. All the rubbish from our bins and these bins get emptied into the same truck. So we have had a long-standing agreement with the council officers down at the head there that rather than any overflow rubbish be seen to be stored somewhere less suitable, that it would be better if we have an extra bag or two of rubbish to put them into the council bins, and we would be charged accordingly for those collections. This has been in operation for some time and has always been in full agreement with the council officers. It is not something we use regularly, and it's certainly, I'm not accepting that all of that rubbish there is ours by any stretch of the imagination.
Well, pausing as an illustration of that, the up at the top photograph has a red crate of, I think that's Budweiser beer.
That does look like Budweiser. We do not sell Budweiser. In the photograph, the stuff that I can identify as our rubbish, pizza boxes, hands up, those are us, and coffee cups, and I can see one Thatcher's can in a bin that we sell. The
wine bottles, are they yours?
The wine bottles are not ours. The green bags and black bags and various bags, they will have all come from Beach Hut residents. That is not our rubbish. Ours goes into our bins on site. That is very reminiscent of any bin in the summer along the 7 miles of Bournemouth seafront, waiting to be opened on a good day.
That's all I'm going to ask you about. There may be some questions about that aspect. No?
If I may, Chair.
Yes, please.
Just on that one. So what I gather is that the bins, your bins, e.g. within your curtilage, rather than these public bins which are viewed here, are emptied at the same time into the same truck. How often is that collection?
I believe this summer it was up to 3 times. We have noticed 3 times a week.
3 times a week, yes.
Not 3 times all summer. We have noticed that since BCP in-house waste collection have taken over, there's fewer trips down to this location to empty the bins than there were before when it was a private company. That is outside of our control.
If I may, at what time of the day are those collections? Those
They
three occasions
are
a week?
collected in the morning. They are down to BCP Council to run those collections. So I would not say that they turn up at the same time each week or each day that they come. It's outside of our control.
If I may, again, Chair, just for the presentation, you said that there's an informal agreement with the Engesbury Head team that sometimes you will use these public bins for additional things.
Yes, they would rather see us put rubbish into the public bins than store it on the floor on our premises effectively until they can be emptied. This is not something that happens consistently or regularly, but in an emergency we would.
And as we've said,
if I may, Chair, so I know it's a technical question, it's a planning question, but there is occasions whereby the bin provision that you actually have currently, you have to use public bins.
Only if there's an issue with bins being emptied on time. If the bins are emptied on time, I mean, for sake of reference, for the summer, we increased from 1 general waste bin to 3 general waste bins on site. So we have to make sure we've got the right number of bins and a provider that can empty them often enough.
and if I can quickly, your instructions to me are replicated in the bold font type that I have provided after proposed condition 19.
Yes.
You say you are happy to agree to placing 2 bins for your use outside your curtilage. Is that something that you're entitled to under your lease to come to an agreement with the relevant part of the council?
It's something that we've had conversations with seafront officers and they are willing to enable that to occur.
And the relevant part of the lease is Schedule 1, I think it's paragraph 7, that would permit that as a matter of the lease.
Yes, adjacent land, I think, is there from that.
I'm going to turn to a different subject very briefly, and that's all, please. If you look at page 33 of the same bundle, we see a photograph of a PIMS tent.
Yes.
Now, the impression might have been inadvertently given that this is something that happens every year and for a continuous period in the year. What are we looking at? When does that photograph date from?
That was the summer of 2019, the first summer we opened. I believe it was the Muddyford Fun Day that we put that.
Other than what we're looking at as the day this photograph was taken, was the PIMS tent put up again?
It has never been used in that at the beach house since.
Right. And if we look at the bottom right-hand corner, of that photograph, we see in typing 2nd of August 2024. Does that refer to the photograph?
That refers to the photo below. It would have helped if there was a border around the images to show that that text is all a screenshot.
And the similar question, if we turn over the page to page 34,
Yeah.
the lower photograph is of a beach burger truck.
Correct.
And again, it might have been thought, oh, well, that's been happening throughout the summer for 5 years. What does that refer to?
That referred to the first summer that we set up, when we had that there as part of the setup, again, in agreement with the seafront officers for that year.
And beyond 2019?
We took it away.
Right. While we're on this page, there's a number of clips and various things. I'm going to take the top left-hand one, Beach House End of Summer Party. What, you know that particular promotion. What year does that refer
to? I couldn't tell you what year specifically.
Located in terms of the fire.
I know that all of those events that are shown there all occurred before the fire.
So the period that has been praised before the fire, you had Kev Jackson's party band?
Kev Jackson's party band with a 3-course Italian meal and return ferry for £28 a head. I'd love to be able to afford to do it for that price these days, but that implies it's at least 10 years ago.
Right. So the suggestion that all of what is now taking place should be analysed as something that's happening after the fire.
I did note that some of the photos presented as evidence earlier of events occurring were also pre-fire.
Well, some carry the date of 2014, I think. But anyway, we'll see what dates they carry.
I think the points noted with regards to the image references, because we note that the PIMS marquee is in the photograph of the beach burger.
Yes, it is. Yes. That was all I wanted to ask Rich. Unless there's more for him, can I turn to him, please? Very briefly, is it true that before the fire, alcohol was only served with food?
No.
And is it true that the premises was set out as a restaurant?
No, it's always a restaurant with a bar.
I've never had my request for short answers met so viciously. It was suggested the rebuild may never happen. What is the reality, please?
Well, that's quite upsetting. I always wanted to rebuild it, obviously, and I don't want to live with. And every year we're having to tart the place up, repair it, because it's going to be knocked down next year, and through no fault of our own, we're sat here with this temporary setup.
Some, if I may say so, pretty unpleasant things were said about you, and it's right you should have the opportunity of answering them. It was said that you're not a license holder that you can trust, and you're unwilling to comply with planning conditions and lease terms.
Well, I've been a license holder for 45 years, and no one's ever questioned my ability to run a licensed premises until this one. It's actually, quite upsetting.
In relation to the proposed condition that the premises shall not be allowed to operate after 5 o'clock unless there is a noise management plan agreed and approved. In response to that, it was said, well, you want to create a noise nuisance before 5 o'clock. Please respond to that.
We don't want to create any noise nuisance, so we're happy to operate with a noise management plan with limiters. I mean, with an open air building, it will be a lot harder and it'll be a lot quieter. And that's the nature of it, and we're quite aware of that. I mean, we're stuck with this situation through, I could point the fingers at people, but we've tried all the time. We're working with the council, and it has ultimately come down to who's going to pay for it. And we've tried, we've given them a plan, and they're happy that I've got to find a big chunk of the money, and they've got some to put in, and we're on the verge of doing that deal with them.
Now, was rightly said, what permissions are given in terms of licensing and indeed planning in relation to the rebuild and your operation in 2027. Looking at next year, the summer season of next year, I think anybody who's listened to this morning's material and this afternoon's, anybody can see quite clearly that there has been acrimony between one party and the other. I would like you please to think of and give what genuine assurance you can that steps are going to be taken to heal that wound and work with the hut owners.
Well, we've always said we'd do that, and we always have.
Well, on October the 31st, we all know you said that one was banned from your premises.
Well, the things that have been said about me personally by Claire Barth, who I thought was a friend, and her children who worked for me, was very personal. And then, obviously, she walked into my other premises, and I was having dinner, and I was told that she was in there. I couldn't believe that she'd walked into the boathouse, and I just assumed it was done deliberately to wind me up.
Well, let's assume it wasn't. I would like some sign that you're prepared to, hard though it may be, put as much of that as possible behind you and work as amicably as possible for this next year. We're just concerned with the year 2026 as amicably as possible and in accordance with the promises that we have made to do whatever we can to ensure that people do not leave the premises with open containers of drink.
Absolutely, yeah. We've already instigated that. That was a mistake, and we will obviously work. We were working very well with them. There's no reason for this animosity, and I realise you've got to get on with your neighbours. You know, we've got to find a common ground. And this summer we've agreed we won't do any events as they're called. And our events really are just an opening party and a closing party. And this year we got asked by a well-known hut owner if he could host his wife's 40th birthday.
Which we've read. I'm not going to ask you to go over that.
So we're going to. Okay, so we're not going to do any of those this summer. We want to do just background music and an acoustic guitar within the sound limiter that you're proposing.
And that's to keep the business going. And then the real work is going to have to be done. We can't really consider it now, but we know it's coming in relation to a license application for the rebuild for the following year.
Yeah, that'll be totally different.
I'm in danger of, I think I've already crossed the line of just repeating myself, so I'm going to stop there and ask if you have questions of Kim.
Any further questions, members, at all?
If I may, Chair. If I may, Chair. I very much appreciate the clarification for the photos which we're seeing, but I'm just currently looking at page 51, which is the 2005 plan. And I know that's out of date because it's been changed by the amendment. And page 42, which is the 2019 floor plan. So I have two questions related to this is an original pack.
Councillor, can I just, so we don't get off to the wrong footing, the plan at 51 is attached to the off-license license, not the license you're dealing with today.
Yes, but it does show out the layouts of what was provisioned, and it relates to one of the questions which has been raised by the objectors for provision which they had, which they no longer have, and it's been replaced by something else.
That's right. Yes, it relates to the
Thank you, Chair. My question is fairly simple. Is there actually a shop provision as there was before the fire?
We do operate a shop. We're currently operating it from...
Microphone, please.
Sorry. We do operate a shop. We're currently operating it from the former Coast Watch premises on the other side, which, again, Seafront allowed us to set up the shop there so that we could have facilities for a shop.
Unlicensed?
It is unlicensed. We do not sell any alcohol from that shop because we didn't want to go through a license application for a building that was meant to be temporary.
Excellent, thank you, Chair. It's just that one of the objectors talked about the loss of the shop facilities.
Yeah.
the question which I have, which is licensing related, if you wish, is again, it refers to the 2019 plan, which actually shows a vans for a burger and ice cream.
Yep.
Are you telling me that such vans don't exist? And if so, they do exist and are in use just now, are not part of your business?
That burger van still exists by the people that own it. We ceased renting it after the summer of 2019. We used it for 6 months in 2019 only and have not put a burger van there since.
Thank you. Oh, just one more one.
Of course.
Because we heard from the officer, Miss Jardine, that she has no record. Can I confirm from the premises here, have they ever applied for a temporary event notice?
In my time, we have never applied for a temporary event notice. Jeremy ran it for several years before me.
Yes or no? No. No.
For that. No. Okay. Any questions at all? No. Okay. Yeah, it's been mentioned about the advertising, but obviously we've gone through those photographs and you've said that they're from sort of like 2019, some of those photographs, in terms of you know, advertising, let's say gigs that you're putting on in the daytime. So are you saying that those have now ceased?
No, the advertising that was presented as evidence that we were putting on gigs solely since the fire, whereas actually some of those adverts were for gigs before the fire. We have still been putting on gigs. To be honest, they're earlier than pre-fire. So we tend to put them on in the afternoon now rather than into the evening.
But for the plans for next year, in summary?
The plans for next year, we will not do any big events such as the rum and reggae, i.e. the start of summer and end of summer party that we normally do. We do still want to do live acoustic gigs throughout the weekends because we feel it generates a good atmosphere and is not a nuisance as suggested.
And the sound will go through any limiter?
It will go through a limiter agreed with the EHO per the noise management plan.
Okay, thank you for that. It's been rather a long day, I think you'd all admit. Can I, at this point, ask if you would like to sum up for the benefit of the committee?
Yes. Impression. I do understand, and it's your impression rather than mine, but I suggest there is nothing in that material capable of being a moral danger to children, capable of supporting the proposition that drunk people are singing and dancing, or, as I've already said, there are vast quantities of plastic and rubbish. What we see is people enjoying themselves lawfully, as they do in harbours, quaysides, riversides, places by the sea, up and down the country. There is, of course, some litter, but if it is as bad as we were told it is, I'm astonished that there is no photograph of it at that scale. Soundtracks, when you listen or when you see the videos, you will hear soundtracks. They are not a reliable source of information as to what could be heard at the time. Much depends on the volume or the setting at which you record it, and much depends on the volume at which you replay it. Soundtracks on videos should be approached with caution. But I'm sorry to repeat myself so often on this. The complete solution to noise nuisance is in the noise management plan. The two principal concerns I suggest that arise in this case public nuisance by reason of music and the taking of drinks from the premises in open containers have been taken seriously and they've been addressed. And they're rather unpleasantly, my note comes to an end without any flourish at all, but that is all that I have made a note of to say in closing.
Thank you very much. Gary, would you like to address the committee in summing up, please?
Public nuisance, which is and always has been the primary licensing objective engaged.
Oh, I do.
Is dealt with in the Secretary of State's guidance, and for your lawyer's note, it's paragraph 2.22, and I'll just read the relevant part. Public nuisance is given a statutory meaning in many pieces of legislation. It is, however, not narrowly defined in the Licensing Act, and it retains its broad common law meaning. It may include, in appropriate circumstances, the reduction of the living and working amenity and environment of other persons living and working in the area of the licensed premises. So for the purposes of the Licensing Act, that is the definition of public nuisance. It doesn't have to be a rave outside your hut. It doesn't have to be people throwing missiles. It can simply be a reduction in the living amenity of the people who live there. Now, having read the representations, having heard the evidence of the residents of their lived experience, can it really be disputed that there is a public nuisance that is being directly caused by the style of operation, the new style of operation, by the operators of the Beach Hut Cafe since the 2018 fire? We say it is clear beyond peradventure that there is a public nuisance in the terms of the Licensing Act. The only question is, what do we do about it? Well, the suggestion of the license holder amounts to, once again, trying to kick it into the long grass. Don't do anything. Suggest a noise management plan. It will all be okay in the end when this is rebuilt. That is not your task today. Any future rebuild, any planning application dealing with the future or indeed the past is actually completely irrelevant to your decision today. Your decision needs to be focused on the existing structure, this open air structure, the existing style of operation and the existing license, because that's what your steps will bite at. So when you look at as we're asked to do, what are the causes of the issues and how can they best be dealt with? Well, the causes of the issues is the premises has gone from a food-led table service, primarily restaurant, into a takeaway bar with sprawling customers all over the beach. Now, you can take into account the impact of customers when they are away from the immediate vicinity of the cafe. The section you had read out by Mr. Gourier earlier relates to when you can impose conditions that impact people after they've left the premises. You obviously cannot impose a condition on a licensee to control the behavior of a customer after they're out of their control. It's a criminal offence not to abide by a condition, so you can't impose that on a licensee. So it's in that context the guidance talks about once immediate vicinity. But it's very different when you come to reviews. And once again, for your legal advisor's note, 11.7 of the guidance, it says this, that in every case, any application for a review must relate to particular premises in respect of which there's a license and must be relevant to the promotion of one or more of the licensing objectives. Following the grant or variation of a license, a complaint regarding a general issue in the local area relating to the licensing objectives, such as general crime and disorder situation in a town centre, should generally not be regarded as relevant unless it can be positively tied or linked by a causal connection to a particular premises. In other words, if you can tie the noise of a drinker urinating outside the beach hut to the licensed operation of the cafe, which in here you've heard a wealth of evidence suggests you can, then it is relevant to take into account on review and to help guide you on the appropriate steps to take. It is the licensing objectives and their promotion that is paramount, not the commercial interests of the license holder. You're being asked to say, well, this can all be dealt with by way of a noise management plan. Now, the noise management plan relates to the new structure, which may or may not get built. It only really cropped up in the context of this case because of the recent plan. Now, you're also being told, well, actually, we're not prepared today to offer any specifics of that. Kick it into the long grass. This is an open-air premises with very little controls over its customers. And we suggest that if you're talking about music breakout, the most sensible thing is simply to do what the license states on its face can be done. No regulated entertainment, because it's not and never has been a licensable activity authorised at this premises. They can only play the live music and recorded music that has, you've heard, created a nuisance and disturbance to residents because of the exemption. And the whole system is set up to permit you, in just these circumstances, to remove that exemption. And that really is the clear solution to the problem. You just remove the flexibility they've been exploiting to the detriment of residents to play music. So it goes back to what their license had always been, no music. You would only go on to consider a noise management plan condition if you reject that submission and think they should, that they have conducted themselves in a manner that justifies them continuing to take advantage of the music exemption. And if you were to go on to that, we suggest no, we suggest the best route is simply get them back to their license. No music is permitted. They can have background or ambient music as it's described, because that is not considered regulated entertainment. But if they ever want any events, they can apply, music events, they can apply for temporary event notices up to their limit. But the simplest thing that will be most effective, it's simply remove the exemption for music. If you're against me on that and think that they've shown themselves capable and responsible to run a music venue, despite the evidence you've heard, then any noise management plan must surely apply throughout the day and not simply after 5 p.m. It's an astonishing submission by the licensing holder that they ask you to restrict them from making a racket after 5 p.m, but allow them to create a racket before 5 p.m. You're being asked to look at the old condition about sealed containers. Superficially attractive. On scrutiny, it's completely useless condition. All you have to do to comply with a sealed container condition for off sales is simply provide cans of beer. And then someone takes 2 steps out and opens the can of beer. All you need to do is you need to serve beer with the swing top beers that you used to have on Grolsch bottles that you just push a button and the ceramic stopper comes off. You just have to provide that. So a sealed container condition, which is put forward as the solution to this, simply gets us absolutely nowhere. It simply means you can't have an open pint glass. You just have a bottle or can that you can open and immediately leave. That's not the solution. The solution is simply to remove alcohol off sales. That means people can drink alcohol within the red line, within the demise, and you know that there is an outdoor area within the demise. Now the building is done, and that is the focused, correct solution to drunken people making the sandbank their party area. None of that is going to control the people noise. So what is it that controls the people noise in this area? It's just stopping people going out with drinks, whether sealed or not. And the solution is you simply remove alcohol off cells. You will form your own view whether Kim Slater responses this afternoon to questions gives you confidence that things are going to move forward in harmony, and gives you confidence as to whether Mr. Slater and the licence holder are going to voluntarily curtail the huge commercial advantage they've got from running this large-scale, essentially pub takeaway. We suggest that experience has shown no. That unless you impose conditions, strict, robust conditions, the licence holder will continue to exploit the permission you give him to the maximum commercial advantage. That is, has, and will continue to create a public nuisance on the sandbank. We have offered you a whole number of potential conditions. If there were, I'm not here horse trading, but if you were to look at what are the primary conditions there that will achieve the proper objectives of this review to prevent a continuing public nuisance, it would be 1, the restaurant condition. It would be 2, the removal of alcohol off sales, and 3, the removal of the exemption for regulated entertainment. But if you were against me on that, a noise management plan that applies all the time. And those are our submissions.
Thank you very much. Right, I will now conclude the hearing. At the end of this meeting, the subcommittee will adjourn in private with the legal advisor and the clerk to deliberate. The decision will be conveyed to you in writing as explained earlier in the day. And I'll just ask the legal advisor just to comment on the appeals process.
I will, Chair, but are we going to watch the videos now rather than not in public session?
Well, I thought they were going to be emailed to us so that we could
watch it before we deliberate.
Yeah, we'll watch it before we
them.
deliberate.
Yeah.
Okay.
Yeah. Okay.
Yeah. Just wanted to clarify where
Right,
that was
okay.
going in.
Did you want the parties to wait for you to announce your decision or to receive it by email?
No. We don't have to provide a decision today. Yeah. So
there'll be no announcement. You'll send it later.
it will come in written format. Yeah. Okay. Thank you for your attendance, everyone.
Okay.